Yes, it's okay. I'm ready today. It's okay. Come. Yes.
Your Lordship, I beg to mention item number 7. I'm appearing on behalf of Neelam Taje petitioner.
Acha. 7.
You, mm,
Why you want time?
Your Lordship, due to some medical emergency, he is not able to.
Neelam Taje has some medical emergency.
Yes, yours.
But Mr. Lia Likhata come.
No, Your Lordship, I'm appearing on behalf of Neelam Taje.
What is your name?
Sita Jo.
C. Tatu, appearing on behalf of Neelam Taje, learned advocate for the petitioner.
7.
And for the state
And
laws.
learned APP of the state of Arunachal Pradesh. It is stated, Mr. So-and-so states that is the conducting counsel, Mr. Neelam Taje, due to some medical emergency, could not come to the
7, 8,
High,
7.
could not come to conduct the case. As such, he prays for a week's time.
Your Lordship, 2 weeks.
He prays for 2 weeks' time. Prayer is allowed. List the matter after 2 weeks on a date fixed by the registrar.
Your Lordship, also one more item number 23.
23.
Yes, Your Lordship.
Yes.
He is, in this case, he is for respondent.
Acha. A similar prayer, item 23, heard so and so, and
Your Lordship, where
you are there for the petitioner.
yes, we are for the petitioner.
Okay.
I fixed on 28th of July.
28.
20th of July.
20 or 28?
2807.
28.
28.
On the prayer made by so and so, appearing on behalf of Neelam Taje, list the matter after 2 weeks. The prayer is not, I'll give you the date. The prayer is not objected to by the council appearing for the petitioner. List the matter on 28
July.
28 July 2025.
And meantime, there is an interim.
Acha, interim passed earlier shall continue till the next date.
Much obliged.
My Lordship. Your Lordship, with the consent from other side, I beg to mention item number 22.
22.
Yes. Your Lordship, here I'm praying for listing this matter after 3 weeks.
On the prayer made by, you are for the
I'm for the petitioner.
on prayer made by so and so, appearing for the petitioner, which is not objected to. He has taken consent.
Yes, sir.
So and so, list the matter after 2 weeks.
3 weeks, sir.
3 weeks. List
And
the
your-
matter after 3 weeks.
And Your Lordship, there is an interim order operating.
Interim order passed earlier shall continue till the next returnable, next date.
Much obliged.
May Lordship. Lordship, I'm for item number 9. Conducting counsel is unable to attend the matter today. Therefore, the matter may be fixed after vacation.
You are for?
Conducting counsel, Mr. D.K. Majumdar.
Oh, D. Majumdar.
Adi
For the
Majumdar.
petitioner.
Yes, Lordship.
Okay.
I have taken the consent from the other side also.
As prayed for by Mr. Somila. What's her name?
T. Kamsar.
T. Kamsar. Appearing for the petitioner. Or appearing on behalf of Mr. D. Majumdar, learned advocate for the petitioner. List the matter after 3 weeks.
After vacation.
After 3 weeks, so after it will be after vacation.
Right.
Okay. After 3 weeks.
Obliged.
Some interim order? No.
Lordship, I beg to mention item number 8.
8.
I on behalf of the R. Taku, I'm for the respondent. So matter may be least effects date 28 July.
As prayed for by the council appearing for respondent.
Yeah.
Respondent number 2. Respondent. There are so many respondents. We are appearing for which?
Actually, he didn't inform me, just one friend.
Appearing for the
In
respondent.
this way.
List the matter after?
On 28th.
On 28 July.
On 28. List the matter on 28th of July. You are there for the petitioner?
I'm for there.
State is respondent number 1, my lord.
You are there?
Yes, your lordship.
Okay. So you can also write that they are present and then.
Obliged.
Your Lordship. Your Lordship, I beg to mention item number 13, Your Lordship.
19. 13.
Yes, Lordship, in this case, we are filing an additional affidavit today, Your Lordship.
Additional affidavit in an anticipatory bail matter
Yes, some relevant document is there.
or to bring into records of
Yes, we have to,
documents.
so that may be taken up today with this AB, Your Lordship.
Acha, you want to call for those?
No, I'm filing an additional affidavit today, Your Lordship.
Ah,
That may be taken up with this AB, Your Lordship. I'm praying for that.
okay. And
Yes.
then you don't want to do it today?
No,
You will do it
yes,
today?
Yes.
Okay. So call for the, this additional affidavit filed by her. You can file a requisition. They will call it.
Yes, Your Lordship.
You write a small check to the court master that you want to call. You want to call for that record to be tagged along with this, and then this will come.
Yes. Okay, Your Lordship. And item number 16, Your Lordship.
16.
Yes, the conducting counsel of this case, Your Lordship, is out of station, so matter may be adjourned today, Your Lordship.
As prayed for by Ms. So-and-so, on behalf of
N Pada, Your Lordship.
Ann Pada, who is stated to be out of station. List the matter. After?
2 weeks, Your Lordship.
After 2 weeks.
Your Lordship, interim is there, so interim may
Interim,
be.
passed earlier shall continue till the next return.
May I, Lordship?
Yes.
I beg to mention item number 24 and 25
24.
and 25 on behalf of tea time.
24, 25. That's a criminal appeal. You could have done it today.
Uh,
Paper book and everything is ready.
Lordship, conducting council is out of station. So matter may be,
Prayed for by Mr. You are for tea time.
no, I'm BCBO on behalf of tea time.
Tea time, yes.
Yes.
Heard Mr. So-and-so appearing on behalf of Mr. Tea time, learned counsel for the appellant. List this matter after
After 3 weeks.
3 weeks.
Okay.
May I, Lordship. Lordship, I beg to mention item number 26. Here I am for the
Sorry?
petition.
26.
Lordship,
Okay.
here I am for the petitioners on behalf of Tavatagum, leading counsel Tavatagum.
Okay.
Matter may fix after 3 weeks, Lordship.
After 3, as prayed for by Mr. So-and-so appearing on behalf of T. Tagum. List the matter after 3 weeks.
May I please?
Yes.
So this is also same, my lord, nature of case, wherein, my lord, without having jurisdiction, my lord. My lord, what happened?
Cubbing decision. What?
My lord, decision rendered by the, my lord, the so-called intra-village territorial customary code,
Oh, that is called as cubbing or what?
not yet established, not yet notified, my lord.
Okay, okay.
So
Achha.
who will be the, my lord, the members of the customary code? My lord, that has not been yet decided, my lord, notified.
Achha.
After, my lord, the Arunachal Pradesh Civil Codes Act 2001 came into force, my lord. But no notification has been given, my lord, constituting the, my lord, judge and the presiding judge who will be the
Then how
member.
are they continuing?
My lord, without, my lord, the following the due procedure of law, my lord, they call their own chosen members and
Okay.
decided the case in favor of them, my lord. That is the only case, my lord.
That needs to be examined
Yes,
again.
ma'am. So therefore notice may be issued and this, my lord, interim, my lord, protection may be granted, ma'am. It is
Interim-
required. Yes, madam, it is
You
required.
want stay of that decision?
Yes, madam. Otherwise, madam, they will implement again, madam, they will harass me.
But interim, let me consider the interim after the other party appears.
No, madam. In fact, so if such is the positions, that they will never appear, one thing, madam. Another thing.
Arey, this
the-
is the court will
madam,
call them.
However, madam, my interim protection, madam, otherwise they will implement, madam. If the executing, they executed, madam, the, madam, way they exercise the power is very, madam,
Two are the members of that committee.
madam.
1 and 2. Respondent number 1 and 2 are what?
No,
the
madam, they are
members.
the private parties, madam.
They are the private
Yes, ma'am.
parties.
Here what happened, madam, they have the power, madam, if constituted, madam, they can preside over. Therefore, we have not made them as a party as because
Not required also.
not required also. ma'am. That's for the ends of justice, madam, till returnable date, madam, if so aggrieved, madam, they will, of course, madam, always
This is Keba decision
have a
only.
decision. Madam. And if, madam, another interesting thing is, the Kaba was concluded on 29 May 2025, madam, and the re-summon was given, on which date, madam, the no order was passed. The order was actually passed on 9 June
Hmm,
2025,
hmm.
whereas, madam, in the decision Kaba, madam, they backdated the, madam, decision. So therefore, madam, it is one of the case, madam, of the petitioners that, madam, in fact, Kaba was held on 9 June 2025.
Hmm.
Madam, impugned decision is 29 May
Hmm.
2025, madam. After,
So you have written retrospective impugn Keba
yes,
decision.
yes, madam. So therefore, madam, this needs to be, madam,
On
examined.
what grounds? That they are not properly constituted, no notifications
Yes,
were
no
issued?
notifications, madam.
Where are the grounds that you have
Madam,
made?
grounds, lordship will find it. Page 12, para 4, madam.
Hmm.
And madam,
The Bango secretary,
Bango secretary system has also been abolished, madam, by this honorable court, madam.
that was abolished.
Yes, madam. There is no system, Bango, forum called Bango level system, madam.
Where
Now-
is that? Do you have any, have you annexed that?
No, no, madam.
abolition?
I'll, at the time, madam,
Acha. And he is the Bango secretary. These are
Madam-
so new terms for me. Bango secretary? Where is
Bango
it?
secretary is the, madam,
Keba Empire.
yes, madam. Who issued, madam, impugn, not, Parvana and conducted, madam, this proceeding.
This Bango secretary
Madam, if,
and the person who had passed the order are same.
yes, madam, they are the authority, madam.
Bango secretary and
Yes.
this is Keba umpire.
Yes, Kaba umpire, but they call themselves as Kaba umpire. Madam, if lordship peruse the impugn order,
Hmm.
it is in page number, madam, page number 49.
Just read the,
Type
because I'm
piece.
very familiar with these. Keba was conducted, okay?
Yes, madam.
And just read it, the impugn order.
Madam, impugn order, na.
Hmm.
Keba was conducted on 29, madam, whereas it was 9th June. Madam.
But then
And-
here it is written, it was conducted on the
Conducted.
same day.
Yes, madam.
Okay.
The under,
9 June, perhaps the order is,
no order
passed,
was passed
but-
on 29, but
Ah.
this order has come
ah,
on 9th, madam. On 9 June 2025, whereas Keba was actually conducted on 29, madam.
so
but-
the order was also passed that day.
No,
Perhaps
no order was
publication-
passed on that day, therefore Keba was conducted.
Acha,
This is, therefore, madam, this is backdated, madam, Keba decision.
acha, just read it then. It was conducted on 29/5.
My lord, on,
Hmm.
under the umpireship of Sri so and so, head Gaon Bura, of Bango Gaon Bura,
Hmm.
secretary, regarding the distribution of the properties between petitioner, madam, the respondent and the petitioner, madam. The village level.
Petitioner is Ripemai. Acha.
Repay, madam,
Hmm,
petitioner, madam.
hmm.
Here, but he is the respondent. In the village level, Keba dated 19 April 2025, held at Nyorak Rakte village. The Kesa Rike was passed in favor of the,
Kesarike is?
madam, this is the WRC bill. This with that,
Oh, this is the place.
yes.
Okay.
In favor of Rippe Mai, petitioner, which was objected by Sri Tumli Mai, respondent in the said Keba. Sri Tumli Mai prepared an appeal on the grounds that his grandfather, late Mirik Mai, had made a declarations that whoever take care of him in his old days and who performed his last rites
Hmm,
shall inherit the Kesha Rike land.
hmm.
Sri
Good
Tumli
one.
Mai claimed that
reason.
he had taken care of the care of late Mirik
Hmm.
Mai during the said old days. The pursuant to the said appeal of a Bango level Keba was conducted on 29
Hmm.
May 2025 under the chairmanship of Bango Secretary. In the said Keba, all Gaumburas were asked to give their respective decisions. There were 14 GB who were gave their respective decision. In the side Kaba, 7 GBs were in favor of the decision passed by the Nyorak Rakte village level Kaba, which was in favor of Sri Ripamai, petitioner Manai. Considering the declarations made by the late Merik Mai, my grandfather, and my father, late father, that whoever take care of him in his old day, they shall inherit the Kesha Rike in presence of the witnesses and the declarations letter of late so and so. Those favor of Sri Tumlimai were also 7 members.
So equal.
Equal, madam.
I'm stating that.
I am stating this is an umpire of the meeting. It is true that the Ripamai made a complaint against the declarations of the late Mai. However, Sri Ripamai should have made the complaint during the lifetime of late Mirik Mai. After making a complaint, you have kept silence for 1.5 years. It seemed that had the Keba been conducted when late Mirik Mai was alive. The late Mirik Mai would have declared and cleared the matter. And today, pursuant to the complaint made by Sri Tumli Mai, son of so and so, as an umpire, they concluded the Bango level Keba and asked the entire GB to give their respective decision. As per the GB's respective decision, it was equal decision, split decision. As such, as the umpire of the Keba, my judgment is that Sri Ripa Mai should have made his complaint before in the Keba when late Mirik Mai was alive. As per the documents submitted by Sri Sri Tumli Mai, wherein it was shown that the declarations with regards to the Kesa Rike was made on 28 May 2022, wherein 5 witnesses were also there. After taking due considerations of the
Okay, I've read. I mean, this Ripe Mai is the petitioner,
My lord,
and the Tumli Mai
is my nephew, my lord.
is
My lord, it is my
relative, some
no,
relative,
my lord, my eldest brother's son.
eldest brother's son.
Yes, ma'am.
And who is who is
Tumli.
Ritum Mai?
Ritu Mai is the my lord.
He died.
Yes, my lord, my elder brother.
Okay. Ritum Mai's son is Tumli Mai.
Correct, ma'am.
Okay. So that lady had 2 sons, Ritum Mai and Ripe Mai, and she had made the declaration in favor of Tumli Mai
Yes, ma'am.
because
Mother and their grandfather.
because he took care of her
Yes.
in her last days. And this Keba Empire went in favor of Tumli Mai.
Yes, ma'am. By this impute decision. But earlier, village level Keba, my lord, where it was conducted in accordance with law. That was proper and my lord, as per the procedure, my lord. Earlier 19 April 2022, decisions were came in favor of me, my lord, as per the procedure, ma'am. Now
he filed appeal.
Yes, my lord. Decisions of the village authority has been reversed by this, my lord, the impugn decision, my lord.
In the appeal.
In the appeal, my lord. And appeal was not, as I pointed out, appeal was not conducted as per the procedure, my lord. There is no notified, my lord, who will be the member of the territorial, my lord, inter-village territorial customary court, ma'am.
No, what is to show that they don't have the jurisdiction? You have annexed something
My
or
lord,
simply
annexed-
pleadings? Because without those documents, it will be difficult for me to give
Yes.
an interim protection. You should have annexed it with the
My lord, this is
petition. Today I'll issue notice, let the other party come,
my lord,
and we will decide on the jurisdiction of the committee on that day.
my lord, it is clear that it has not been, my lord, notified, madam, as of now.
But then I'll have to hear the other party
My lord,
also.
there is,
Because I'm not aware of this village customary rules. So today, as of today, I'll give notice, let them appear, and then we will decide on the interim issue.
Then in that case, my lord, on next date, my lord, the interim.
Next date, as soon as possible, as soon as it can be served.
My lord,
You can serve him by Dusty.
that's
They are
the-
relatives.
that's the, my lord, at the.
The elder brother's son and your own brother. Your own
Sure, my
brother,
lord.
right?
My lord, we are fighting each other.
Still, then it will, I mean, this will become fast and the notice will be served soon.
Yes.
Then interim you can get, if at all they don't have
As well
the
as, my lord,
jurisdiction.
Dusty as well as no, normal.
Acha, acha, okay. I heard Mr. So-and-so appearing for the petitioner. This civil revision petition has been filed challenging the order. Challenging the order dated, this is challenging the order dated 29/5. I'll write 29/5 only. What is the date given in the original copy?
Yes, ma'am, 29/5/2025, ma'am.
Huh?
29/5.
12/6/25. What?
12.
Oh no, 29/5. Yes.
Yes, ma'am.
Order dated 29/5/2025. Passed by the Inter-Village Territorial Customary Court by which it was decided that Kesarike, by which it was decided that a property to be given to the respondent number, one, Tumli Narak.
Both, ma'am.
Tumli Mai.
Yes, ma'am.
Both. And who is Tumge Mai?
Tulgamai is the brother of Tumlimai, respondent number 1, ma'am.
That of course is not there in the decision. It's only in
Yes.
respect of Tumli Mai. So was given to respondent number 1 on an appeal filed by him on the ground that respondent number on the ground that the mother of
Father,
the
ma'am.
petitioner, father of the petitioner had made a declaration that the property would go to his son who had taken his care during his last days. The counsel for the petitioner states that the said customary court do not have jurisdiction to pass such an order. Issue notice to respondent number 1 and 2. The petitioner to take service of notice upon respondent number 1 and 2 by registered post with AD as well as by dusty mode within 2 days he has the petitioner to take these steps within 3 days from today. Okay.
Madam. Madam,
Will you file an affidavit of dusty?
yes, madam, if,
Further, if he serves the notice by dusty mode, the counsel for the petitioner is at liberty to file an affidavit to that effect.
madam, may kindly add one thing, madam, on next returnable day, the interim period will be considered.
Yes, the interim to be considered on the next returnable date. List after,
The fixed date in that case, madam.
Okay. list the matter on. You suggest a date?
23rd, madam.
23rd, yes, 23rd of July.
Development.
bail application.
Yes, Your Lordship.
He is inside since
Now it is almost 6 months.
6 months.
Yes.
Allegation is
This 102, that is of
Murder.
Yes. But if we look at the charge sheet also, my involvement is not there.
but anyway, we have to see the scan copy of the
Yes,
trial
yes,
court records.
yes.
Yes.
That, I mean, the hearing is done, this charge framing vagera is done.
Yes, yes. The
Suppose
charge-
it was done.
Yes.
Trial is on.
Yes.
So let the scan copy be called for. This instant bail application is filed for, and, no, not required, heard Mr. So-and-so
K. Taja.
and Mr.
Tado.
T, no, no.
G Tado.
G. Tado, learned additional public prosecutor for the state of Arunachal Pradesh. Call for the scan copy of the. Just right, this is an application filed under section 483 of the BNSS Act, BNSS 2023 for grant of bail to the petitioner in connection with Doimuk Police Station case number 181 of 2024, registered under section 103 within bracket 1/238. What is 238?
It is
Causing disappearance of evidence.
Oh, causing disappearance. 201 is now
Now, yes, it was,
201, right?
earlier it was 201.
238 of the BNSS. Full stop. Call for the scan copy of the case record. Trial TCR, trial case record. What? Trial court records, yes. Trial court records, listed after,
Your Lordship, may I have it on 2nd July?
listed.
Mm.
By the time the trial court record should also come. From where will it come? I mean, what is the court?
Yeah, it's nearby, UPia.
Nearby?
Yes, just our session court.
Okay. And then list it on.
Today,
What date you want?
today is 27th and,
It's 25th.
Today is,
Oh,
today is
sorry.
25th. So, list it on 3rd of July?
yes.
Your Lordship, then 4th July.
3rd of July.
4th July then. 4th July.
4th July.
Yes.
4th July, I'll leave early.
Then 3rd.
4th July.
3rd then also. Okay.
3rd July. 3rd July, 2025.
Obligers.
Oblige, Your Lordship.
Oh, you are there? Yes.
Under section 528 BNS. So setting aside the search sheet as well as the cognizance order taken by the court below.
Acha, wait, you have challenged the
Silence, right, silence, the search sheet as well as the cognizance taken. Yes, FIR and the cognizance taken by in Excerpt D, page 53.
Only cognizance is taken.
My lord,
Nothing-
notice issued, my lord, subsequently warrant also is issued, my lord, this subsequent order.
Because he did not appear.
This, they are from different place, my lord, and here, my lord, the last, page 57, my lord, my junior appeared, my lord. Now the order is, my lord, on 23/2025, my lord, page 57.
Page 57.
Yes, my lord.
Hmm.
The issue warrant against the accused person as the reason cited, the absence appears, the 2 p.m.
Mere
appears to
excuse.
not appear before the people are file an the application. Dispense application for the accused as such, the dispense application is rejected, produce and available warrant of 2000.
This is bailable warrant of
Yes,
arrest.
yes, my lord. Here, my lord, my case is my lord. Not these are all the army
Hmm?
personnel, my lord.
What?
Army personnel, my lord.
These are army personnel,
Yes,
I
my-
can make out.
Yes, my case is, my lord, please, cognizance was taken, my lord, without taking the proceedings sanction, my lord. When they are working in a disturbed area, my lord, as armed force special act, my lord. And so far, the old CRPC of the new, my lord, the also, my lord, the proceeding sanction is required, my lord, from central government, my lord. Here, my lord, is, my lord, what happened, my lord, your lordship may turn.
What is the allegation?
Allegation, my lord, is the section is, my lord, 304, my lord. Charge sheet,
Of
my lord,
BNSS or what?
uh, IPC, my lord,
Acha, acha.
IPC
304,
304 to 326, 323.
34.
In this case, my lord, there is also one that PIL also filed, my lord, before his honorable court, my lord. There is
And there is no prosecution sanction
No,
before
my lord.
taking cognizance?
No, my lord. And my lord, there is also, my lord, this, the PI file in this case, my lord, there is a judicial inquiry report is there, my lord.
What is it? 304, 326? It may not be in his official duty.
No, my
So
lord.
no prosecution,
No,
no sanction.
no, completely official.
Acha.
This judicial inquiry report also speaks, my lord, last page, my lord. Last page, my lord.
You are for?
Your Honor, I am for SIT, Special PP SIT.
Acha.
And my lord,
Mm.
this morning only I have got this copy. Actually, what happened, the filing section, they gave wrongly to the PP. So
Oh.
since in the case title,
In a cost title, it's written PP.
yes, so that is why, so it needs to be also corrected.
Special PP for the SIT.
SIT,
So let him go through then.
My lord,
yes.
what about case is fixed tomorrow, my lord, before here on judicial message.
You should go and appear because he
No,
did not
my-
appear for so many days.
My lord, what happened, my lord, I'm coming on, my lord. Whether this, my lord, in this case, my lord, lordship, this, I'm giving the copy of this judicial inquiry report to my friend also, my lord.
Mhm.
Last page, my lord, conclusion, my lord. What the allegation is, my lord, the last page, my lord. Here,
This is, okay, this is an inquiry report.
yes, it is inquiry, judicial inquiry report, my lord. After filing the PIL, my lord, after filing the PIL, my lord, this, there's an order, of
Wait, I'm not clear. What is the PIL about?
PIL about this one person died, my lord.
Acha, acha.
As per their allegation, it is fired from the army personnel, my lord.
Ah.
So in this case, the SIT was there, my lord, and the SIT filed search sheet, my lord. Search sheet, in this search sheet also, they mentioned that they are apply for proceedings sanction, my lord,
Mm.
but not received, my lord.
Mm.
That is there, my lord. And side by side, one PIL was filed before his honorable court. There is direction to judicial inquiry, my lord. The judicial inquiry report is
In respect of the same offense?
same offense, my lord, same offense. So this conclusion, my lord, phase 18, my lord.
Acha. I just wanted to go through the FIR once.
In the last conclusion, my lord.
Huh.
The judicial district judge report, my lord,
Mm.
district session judge. On conjoint reading all the statement on record, I find that when the villagers started placing stone on the army personnel, in order to disperse the mob opened fired toward the different direction in which the disease who arrived at the spot from different direction received bullet injury and succumbed on his injury at the spot. Had the army personnel opened fire upon the villagers with AK-47 rifles as alleged by the villager, many of the villagers would have been died in the said incident. Therefore, I find nothing to hold that disease was intentionally killed by the army personnel. So, my lord, here, my lord, basically my case is, my lord, this in their search sheet also, your honor.
Of course, if they had, people were pelting stone upon the army personnel,
Yes, my lord.
then definitely they will have to take care of themselves, and for dispersing the mob, they had fired. So
Yes.
that will come within the discharge of official duty.
Yes.
Because there are, I think, so many Supreme Court
Yes,
judgments.
that's
also.
when I am.
Yes, I have.
And my lord, this page 50, my lord, of search sheet, my lord.
Of the petition.
Yes, my lord.
My lord, still, my lord, may I pray for matter to be listed for tomorrow, my lord, because,
Tomorrow, my lord, is difficult, my lord.
Because he has to go through here.
Yes, my lord, that is the thing.
I'll be here, my lord.
No, it will not be very
Yes, my lord.
possible for him to go through.
Yes, my
within
lord,
a-
I have to assist
My lord.
properly, my lord, so that's.
Do?
My lord, then, my lord, tomorrow, so my lord, that may be a possible.
Because this is only BWA. You should
No, my lord,
appear.
no, my lord, this BWS, this main case is, my lord, this, the one captain is there, my lord, this, whether they, the SIT, my lord, without taking the proceeding sanction, my lord, this, they are, search sheet is their record, my lord, this is not new record, my lord. So it is with the council also, my lord. So
So
I'm
that
looking-
is okay, but then this petition he did not have.
Petition, my lord,
So-
this petition is, my lord, we filed on 19, my lord. And thereafter immediately we some, they were served, my lord. This set of, Arunachal is there, my lord.
Mm.
So on last occasion, it was, Metro was speaking, displayed before this honorable court, my lord. On particular date, my the council from the SIT informed the court that copy was not served, my lord. Immediately on same day it was served, my lord. You know, my clerk served same day. On last time there's an order, my lord, from this honorable court, my lord. Now the matter was again listed. This is not first time, my lord.
19/6 it was listed.
On that day, they approached, they informed the court, madam. On that, I also partial, madam. That we have not received, and immediately on the same day it was.
It came up on 19/6.
Yes, ma'am.
Still you did not get the copy.
19/6, no. 19/6, I did not get the
Yeah,
copy. Your
Now
Honor.
it is 25th.
You know, today I only, this morning,
Prayer was made by you.
Yes, madam. On that day, it was there, it is on record, madam, and in virtual, madam. They asked copy, madam, accordingly to we served, madam. So may not be.
You served the copy upon him.
Yes, my clerk served, madam.
It was given to
no,
you.
you're not from,
SIT,
this
SIT, I
morning,
don't know who is appointed.
this morning-
Lady on that day,
Oh, no,
You-
your clerk has served it on the public prosecutor.
one lady was informed.
yes, Your Honor,
My-
that is the
my
thing.
simple prayer, madam. This search sheet is their record, their record.
Hmm.
Rest part is only my prosecution sanction part, my lord. So page 50, my lord, last part.
Can you do it in the second?
No, you know,
No.
no, you know, maybe tomorrow, my Honor. My lord.
Still back.
Because, my lord, because, my lord, in the case title also,
So it is.
PP is reflected. So that is why, you know, SIT's name is not reflected here. So that was, that is the reason.
This report, the judicial inquiry report, it is PI, after filing PI. It is before them also, they participate, state of Arunachal is participating. So the conclusion of the judicial report is dear, so taking time, my lord. It is-
No, your only apprehension, your only fear is that
and-
tomorrow he has to go and appear.
Yeah, and not now, all the accused person or the.
All the four.
All four. And another thing, yesterday I came to know, my lord, another is whose name was the cognizance order. The warrant order was issued against him also.
Hmm.
So whose name was not there in my mobile, and the name is there. So that person, this court below issue notice for warrant arrest.
Hmm.
His name is not in the cognizance order. So basically this last, your lordship may just bear with me, page 50.
And my lord may kindly take up in second
Let
half.
Second half,
Yes,
second half.
second half in that case.
Second half.
Yes,
Second out,
oblige.
at two.
At 2.
My place, Lordship.
Hmm.
Lordship, this is a joint criminal petition.
Hmm.
Why
For
the-
settlement.
Yes, settlement.
Yes, sir. This is a joint petition by whom? The
By-
petitioner and the,
Complainant is
And the
petitioner number
victim.
1. Yeah, victim. In fact, Lordship,
what is the offense?
since Lordship, offense, Lordship 448, the house trespass, this is compoundable.
Hmm.
323, punishment for voluntary causing hurt, 1 year in
That
prison.
will also be compoundable.
Only one section, Lordship, 354D, stalking.
Oh,
3
354
years
D.
only, yeah,
Huh?
yes. 354D.
Acha, okay. Where is the FIR?
FIR, Lordship, is at page number 19, Lordship.
Okay. That this morning.
19 is that I have copied. May I read, Lordship?
Yes.
That this morning at 2:30 AM, dated 3/4/23, Sri Tunga Bagra, he is the accused petitioner number 2. Lordship.
Tunge Bagra is who?
Accused petitioner.
Okay, petitioner number 2.
Yes.
Yes. Son of so and so.
So-and-so
Had
had
wrongfully-
wrongfully entered into my rented house, situated Old Market Alo, and destroyed my gas stove, mirror, bench, clothes, and many household items, including glass etc., and also badly beaten me. Kindly arrest the accused person and take strong appropriate action against it. Now, this is the FIR, Lordship. In fact, the brief fact, Lordship,
Hmm.
both the petitioners, they had a love affair since 2022.
Oh,
And it was on the night, there was a cultural program night on the eve of Mopin celebration.
mm,
It was too late night. So the petitioner number 2 accused, he being a caring husband,
mm,
requested her to go for the house because it was too late night,
mm.
which she was refused.
Mm.
Accordingly, both
They are husband and wife? No, they are in
No.
relationship.
were in relationship.
Mhm. So the boy said to the girl to go early to
Yes,
home.
yes.
Then,
So she was refused,
mm,
where both started heated argument.
mm.
Then after at 2:30 a.m., girls went to her rented house. So the boy
He went to her rented house.
yeah.
Because who
Both-
is the
both-
girl, who is the boy, difficult to
Yes,
understand.
petitioner
Okay.
number 2.
Mm,
He also followed her
mm,
to her rented house.
uh-huh,
There also both started this argument on the same issue.
mm,
So heat of the moment,
mm.
the
Okay.
accused petitioner number 2, he damaged some belongings of the dead lady. But no physically assaulted. Medical report. I have
323 only, right? Medical report is there?
yes, I have enclosed page 30.
Yes, 30.
Not even simple injury, Lordship. It shows it was
Nothing
Not out of it.
abnormal detected.
yes, no injury found at the time of examination. Nothing.
No injury found at the time of examination.
Yes. FIR shows Lordship, it was lost only out of anger only because some belongings was damaged.
Cognizance was also taken.
Yes.
And then,
And then Lordship,
oh,
thereafter,
charges also framed.
charge sheet, yes, Lordship, charge sheet was also framed.
Charge
Charge
framed.
were framed. And now it is at the PWS stage, evidence stage where complainant has to be examined.
Where is the settlement? Acha.
Settlement at phase number 34, Lordship,
Mm.
3-4. Settlement was entered on 6th day of October 24.
Okay. So what do you say? I don't think so. It can be compromised.
Yes.
It can be settled.
Yes, they already settled their dispute.
Not a big offense.
Yes.
Okay. Heard, Mr.
KLOL.
You are K. Lawlen.
Yes, yes.
Heard Mr. K. Lawlen for the petition and Mr. D. Loy.
Yes.
D. Loy, the public prosecutor for the state of Arunachal Pradesh. Para, this is a joint petition. No, this is not. This is a criminal petition. This is filed under the inherent power.
Yes, Lord.
This criminal petition is filed under section 528 of BNSS 2023 for invoking the inherent power of this court. No, for invoking, nahi, for quashing of the quashing and setting aside of the FIR dated 3/4/2023.
Yes,
You
ma'am.
can sit, both of you will take some time. 3/4/2023 registered as Women Police Station case number 2 of 2023 under section 448/D/324-D/323/427 of the IPC. As well as for quashing of the charge sheet being CS number 5 of 2023 and the trial proceeding registered as GR number 16 of 2023 registered under the aforesaid section and which is pending trial before the learned CJM ALO. The petitioner has prayed for quashing of the aforesaid proceeding only on the ground that they have entered into a settlement by deed of agreement dated 6th of October 2024. It be also stated here that the instant petition is a joint petition filed by both the informant and the accused person. The brief fact of the case, as is revealed from the first information report, is that the informant who is petitioner number 1 herein had lodged the said FIR stating inter alia that the accused person wrongfully entered her rented house and destroyed her household articles and had also beaten her up. The police registered the case and on completion of the investigation submitted charge sheet on 29/9/2023.
Yes, Lord.
On 29/9/2023. Thereafter, cognizance was taken.
Yes.
Thereafter,
Yes.
the charge sheet, the charge sheet was placed before the learned Chief Judicial Magistrate,
Hall.
cum Civil Judge, West Siang District, Senior Division,
Yes.
West Siang District, and the learned court took cognizance of the offense on police report on 3/11/2023.
Yes.
Thereafter, charges were also framed
On 28.
by the said court on 28/1/2025
Yes.
against petitioner number
2.
2, against petitioner number 2 under sections 448/323/427 and /354D IPC. Thereafter, the trial proceeded
Yes.
and now it is at the stage of examination of witnesses.
Yes.
Mr. K. Lawlen, appearing for the petitioner, submits that the story behind lodging of the Ejahar is that the petitioner, that petitioner number 1 and 2 were in a relationship, and that on 3/4/2023, during the mopping celebration. What is mopping celebration?
Yes, Lord.
Mopping is what?
Mopin is the Galo festival.
Garo festival.
Celebrated by the Galo community.
Acha, acha. During the mopping celebration, the petitioner number 1, Bagra is 1. No, 2.
No.
Oh,
Bete is 1.
Yes. So in celebration, petitioner number 2 told petitioner number 1 to leave the said festival ground as it had become very late at night. But when petitioner number 1 refused to leave, both of them argued with each other, which led to a minor scuffle between the parties. But both of them, when the petitioner number one refused to leave, comma, arguments took place between them. Arguments took place between them, which led to a minor scuffle between the parties. And that thereafter, petitioner number petitioner number two went to the rented house of petitioner number one. No, yes. By the time, petitioner number one and waited there. In the meantime, petitioner number one reached her rented house, and again heated arguments took place between them. And in the process of, and in the midst of such argument, there was a scuffle and articles were damaged. He further submitted before this court that out of anger, petitioner number one lodged the ejahar, alleging that petitioner number two wrongfully entered into her house and damaged the articles. Mr. K. Lawlen, had also placed the medical certificate in respect of the petitioner number one, which is annexed in the,
As Lordship, annexure number 2,
and which is annexed as annexure 2 in the instant petition.
2 series.
And the same reveals that no injury was found on the body of the petitioner number one. Mr. Lawlen thereafter places the deed of mutual settlement entered into between the petitioners, which he has annexed as annexure 4 in his petition. On the other hand, Mr. D. Loy, the learned public prosecutor, in his usual fairness, submitted before this court that the incident is the incident reflected in the FIR is amongst the revealed in the FIR is personal to both the accused and the informant, and that the same has no impact on the society at large. And as such, he states that he has no objection. He has no objection in quashing of the criminal proceeding in the interest of justice. I've heard the learned counsel for both the parties and have gone through the records. It is as submitted by the petitioner, an issue which is between the petitioner and the accused person. It is stated in the petition. Where is the story written in the petition? Where are the pleadings?
Federal Lordship, tweet. para 3.
It is stated in the petition more specifically in paragraph 3 of the petition that on 3/4/2023 during the cultural program on the eve of Mopin festival, both the petitioner and the accused person were present and were enjoying the same, and that thereafter, when petitioner number 2 requested petitioner number 1 to go to her house as it was late at night, petitioner number 1 fought with him. Petitioner number 1 refused to return and fought with him. It is also stated in the pleadings. It is also present in the pleadings. Oh, no. It is also a pleaded case of the petitioner that thereafter at 2:30 a.m., petitioner number 1 went to the rented house of petitioner number 2. And on meeting her there, they again fought. And in the heat of the moment, petitioner number 2 damaged some household articles. It is also pleaded that petitioner number 2 never physically assaulted petitioner number 1. From the said facts, it can safely be deduced that out of anger, petitioner number 1 lodged the FIR before the officer in charge of the police station Alo. As stated above. Although it is stated in the FIR by petitioner number 1 that she had received injuries, she had suffered. What did she write? Wait. That she had, although it is written by so-and-so that petitioner number 1 had beaten her up. Okay, had beaten her up. However, the medical report in respect of the petitioner number 1 does not reveal any injuries on her body. No, what did I say? The injury report or what? Medical report. Body. And it is also revealed that the medical examination of petitioner number 1 was conducted immediately after she lodged the FIR, that is on 3/4/2023. Time is not given here, no, in the medical report. Time is not given. It's okay.
No loss.
Immediately.
On the same day.
On the same date, yes. Para. The deed of settlement, which was annexed in the writ petition, also reveals the deed of settlement entered into by both the parties, that is petitioner number 1 and 2, the aggrieved party as well as the informant, reveals the same story as it was pleaded by the petitioner in the petition. And in the said deed of settlement, petitioner number 1, no, petitioner number 2, tendered unconditional apology for his misdeed to petitioner number 1 before the families of both the parties. And it was also stated that petitioner number 1 unconditionally pardoned the petitioner number 2. And this first party got married to someone else.
Yes.
And it is also stated that and it is also stated that petitioner number 1, after the incident and before the deed of settlement, got married and is having a peaceful life with her husband. Para. As it is a settled position of law, as is held in various decisions of the apex court, such as Gyan Singh versus so-and-so, Ahir Parvat Bhai so-and-so. I'll just give those in the chamber. I'll give the
Yes.
numbers and all. Do you have those judgments?
Yes, I have.
Oh, then you can give. As has been held by the apex court
Yes.
in Gyan Singh versus
State
so-and-so,
of Punjab and other,
reported in
2012, 10 SCC 303,
wait.
Pravat by Ahir versus.
Okay. And what is the little finding you can give me if you
Fi-
have the printout of Gyan Singh?
I have already given the citation.
It's okay. Or Parvat Bhai, anything.
Yes.
What have you given?
Let's say,
Of
here,
Gyan Singh.
yes. This offense, the offense,
Which paragraph?
areas of para 58 and 61.
28.
58, 58 and
58.
61 laws.
Okay. Mm.
Your Lordship, Honorable Apex Court held that the offense arising out of matrimonial,
Yes, I've got
particularly relating to dowry, etc., or a family dispute where the wrong is
Yes, yes.
basically to the victim and the offender.
Okay. What did I say? The Honorable Supreme Apex Court? In various decisions. Wherein the Honorable Apex Court had observed that the High Court, while quashing criminal proceedings on settlement being arrived between the parties, must give due regard to the nature and gravity of the crime. It was held that in cases of heinous and serious offenses involving mental depravity and offenses like murder, rape, dacoity, etc., cannot be quashed even though the victim or victim's family and the offender comes to a settlement. However, the apex court had further observed that criminal cases which is of civil nature or in relation to family disputes where the wrong is basically private or personal in nature and the parties have resolved their entire dispute, there can be no impediment to quash criminal proceedings in connection with the same. Similar observations were also made
In
Prabat
Prabat
Bhai.
Ahir versus State of Gujarat,
reported in,
2017, 9 SCC 641.
and there is also one Lakshmi, I think. that
Lakshmi
is someone-
Narayan, yes.
And as well as Lakshmi Narayan versus state of so-and-so. Yes, it is. Yes, as well as state of Madhya Pradesh versus Lakshmi Narayan and others reported in, am I going too fast? Acha. Reported in 2019 5 SCC 688. Stop. It is clearly noticed in the instant case that the issue at hand is personal in nature between the petitioner and between the informant and the accused person. And it is also seen that the instant petition is filed by both of them, by both the parties for quashment of the FIR, the charge sheet, and the criminal proceeding on the ground of settlement. The apex court had also observed in the aforesaid cases that every aforesaid cases that where there is no chance of an effective trial between the parties and there is no chance of any conviction of the accused person, the High Court may entertain the quashing of the criminal proceedings instituted against the accused person. As such, this court quashes the FIR dated so-and-so, dated
3/4/23.
3/4/23,
Yes, yes.
lodged in registered in connection with
Allo women PS case number.
Allo PS case number,
Women PS case.
Allo Women PS case number,
2/23.
Allo Women's PS case number, 2/23, as well as the charge sheet submitted in connection thereof on
29/9/23.
29/9/23, and the subsequent criminal proceedings
Yes. Being GR case number
in GR case number so-and-so,
16/23.
full stop. And nothing else. What else? This petition is disposed of. There was one line, I think, after that, I forgot. I'll tell you. Okay, this petition is disposed of. I've quashed.
Deeply obliged.
Give him, Mr. Loy, you can take that judgment. Oh, no, who given? You had given. Take it. Yes,
Mayor Lordship. Mayor Lordship.
yes.
Lordship, this is file under section 528 inherent power of High Court for quashing of order passed by the special judge POCSO, where is directed to for ossification test. When
Ossification.
yes, ma'am. When there was an overwhelming and certificate to show that the age of the prosecuting
Is
court.
minor.
Yes.
But then, just give me that, JJ Act. No, JJ Act provides that in absence of so-and-so,
Yes,
you
but-
can go for ossification. And, I think it is birth certificate and what? Play school. No,
Play-
no, other than play school.
Section 94 says,
Section 94?
yes. It says that lordship, date of birth certificate from the school.
Wait, wait.
Page
just let
48,
me take
Lordship.
out. Yeah. So the first is birth certificate from school
Yes, ma'am. For the
or the matriculation or
matriculation, or
equivalent
it-
certificate.
yes. Since
So those were there.
lordship, here in the headmaster, the school headmaster has given a certificate saying that her date of birth is so and so. It's given.
On the basis of school register,
Yes, Lord, on the way. School-
but then that will not be an evidence here.
And lordship, here the on odd on 164 statement, the mother and the daughter, the prosecutor has stated lordship, the age. So that is a clear lordship.
That is not contemplated under this section 94. 94, you require a birth certificate from school and then, or a matriculation or birth certificate by corporation, and in absence thereof, ossification.
Lordship, here in lordship, in the judgment of 2013-7 HCC,
Hmm.
Journal Singh and State of Haryana, it's also stated lordship here also here the prosecuting was class, he has flung her class 3.
Hmm.
And there on the production of the school registration certificate, the High Court has convicted, special judge has convicted on the basis of that record also. And the High Court also confirmed it. And the Supreme Court also has said, if when there is a registration of the school of the prosecuting, that has to be considered, Lordship.
That judgment is after this amendment.
Yes, Lordship, it's 2013-7.
This is 2015.
Mhm.
Act is of 2015.
Yes.
There is some difference in 2010 rules. Anyway, I mean, what is the stage like? This is
Lordship,
the,
it's for framing of charges. Lordship, what my the pray before this honorable court. Even Lordship, the ossification case is not a conclusive case.
no, but then, see, in POCSO, while determining age,
Hmm.
this is the procedure that has to be undergone. See, birth certificate and so. Now, medical, something is not a conclusive evidence, that is different, that is a general law. But here, for determining the age, you have to have this, you have to follow these three.
Lordship, may I take here also the under 164 statement given by this 183 of the before the magistrate. The girl she stated herself that
No, she will not know
And
no
even-
exact age.
Lordship, the mother who gave birth, she also stated that to be that which correlate with the date of birth given by the prosecutor.
No, those are sufficient proof, but had not there been any challenge against that? If someone challenges that no, these certificates are not enough, this evidence is not enough,
Hmm.
then you have to go through all this.
Lordship, my
Why are you fearing for that
I'm not
ossification
fearing,
test?
Lordship, like, even if there's a ossification, that will cause a trauma to the prosecuting, Lordship. My under,
This is a POCSO case.
yes, Lordship,
And the ossification is of the victim.
yes, Lordship.
Same analogy applies actually. And we have to think about the accused person also.
Yes, Lordship.
You are for?
I am for the petition, that the accused person, Lordship. That
You
the
are for
petitioner,
the accused
yes,
person.
Lordship.
Petitioner.
Yes,
Applicant.
from the petitioner side. He's out of station for his personal exigency, so kindly, maybe
Prayer is
pe-
made by your
the
name.
holidays.
Your name, just write it. A prayer is made by so-and-so on behalf of G. Taluk, learned counsel appearing for the appellant, that the conducting counsel is out of station,
Yes, sure. Yes.
is out of station. And as such, he has prayed for 2 weeks' time. As such, he has prayed as such, he has prayed that the matter may be listed after 2 weeks. Prayer is allowed. List the matter after 2 weeks.
My lord, there is an interim order.
Ah,
That may be
on a date to be fixed by the registry. The interim passed earlier shall continue till the next date. Hearing.
Yes, madam.
And the records are here.
Records are there, madam.
PCR is here.
Your Lordship, if your Lordship remember this case, your Lordship has given a chance to find a citation to show that during the period of trial, if bail can be granted, your Lordship.
It came before.
Advanced stage, at the advanced stage, whether bail
Oh,
can be.
yes, yes. You had given one judgment. I
Yes.
wanted you to find out
Yes,
one.
yes.
Okay.
My lord, that's judgments is good judgments, but my lord, whether still one prosecuting witness is there to be examined, my lord. And
I
whether
think
that,
judgment speaks of ordinarily. I think ordinarily,
yes,
right?
Yes, yes.
Ah.
and that is also, that is to the victims when victim is not examined.
Mm.
No matter whether this stage can be counted as a advantage, advanced stage or not, my lord. Because after prosecution evidence, there will be a 313 and depends and argument, final argument, judgment that will take, my lord, more.
Right. And if he adduces defense evidence, that will also take time.
Yes, my lord.
So, yes, but then this is almost a last stage. But what is the merit? Do you have a very strong merit?
Yes, my lord. After seeing all the prosecution evidence, the accused cannot be convicted for the murder. And he can be
Oh, this is a murder case?
murder case, my lord. He can be convicted under 105 of BNSS, part 2, my lord. That was part 2.
Hmm.
Punishment is up to 10 years, my lord.
Without knowledge, intention, something.
Yes, yes, my lord.
But
Because without the statement of victim, accused, they cannot be convicted, my lord. There is no eyewitness.
this is a murder case. The trial is almost to be over. And will it be fair to entertain at this stage?
My lord, if satisfied, if there is chances of flight or there are chances of absconding, then absolutely, my lord, bail can be rejected. But my lord, here, he accused and the victim were in relationship, my lord. And accused himself brought to the victim to the medical, my lord. And my lord, accused was working as a chowkidar in TRIMS medical, and his father is working as a UDC in the education department, my lord. And he is the indigenous people of the Arunachal Pradesh, of Apatani, Warsaw district, my lord. There is no chance of absconding or.
Did you get any decision opposing her?
Opposing her, my lord, exact that
Of course, he will not get. But
decision I
but interpretation of ordinarily and all.
yes, ordinary, my lord. My lord knows, bail is the rule.
Bail is the rule, yes, I know.
Yes, my lord.
Although in between it changed a little, but then again it has come back.
Yes, ma'am.
But then still she has a point and we have to overcome that decision. And at least the interpretation of ordinarily has to be seen.
Yes, ordinarily has to be seen, my lord. Because PEC also has to be seen, my lord. But in that case, my lord, there was a allegation of rape case, my lord. Victim was still to be examined, my lord.
Mm.
And here, my lord, all the witnesses, important witnesses has been examined. Only doctor is remand, my lord. So tampering of the.
And those statement of the witnesses are in your favor? Nothing against you?
Nothing from that, nothing can be gathered, my lord. And my lord, I brought one last, I was examined, my lord,
Hmm.
on 19. From IO itself, my lord, the position of IO itself, my lord,
Hmm.
cannot be.
The accused is Kuru Tarang,
Accused, the father is the Kuru, accused is Kuru Halu. Ma'am.
Kuru Halu.
Yes, ma'am.
Father has
Yes, ma'am. My lord.
sworn the affidavit.
Yes, my lord. Only my lord may Cross only, my lord, cross,
Hmm?
cross.
Which page you want to
Page
show?
4, my lord, cross examination by defense, my lord.
Page 4.
Yes, my lord.
Page 4.
No, not my petition, my lord. I'm
Oh, yes.
talking about its
Oh, the
IO,
judgment, yes.
IO, my lord, IO.
Oh, IO.
Statement for IO, my lord.
IO is examined before the doctor.
IO was examined before the court, my lord, trial court.
No, before the doctor. Doctor is yet to be
Yes,
examined.
yes, no, before the doctor.
Normally, doctor is examined before. IO should be examined in at the last.
Doctor was, yes, my lord, exactly, my lord. Doctor was also called, but doctor did not appear on that day.
Oh, acha.
So IO appeared.
Was there,
Yes, ma'am.
So which page 4?
Phase 4, my lord, cross
Oh.
examination defense. It is fact that as per the investigation, I came to know that both the accused and deceased were in relationship.
Hmm.
During investigation, I have not found any previous quarrel among them.
Hmm.
It is a fact that there was no any previous enmity between them. It is a fact that there is no eyewitness to say that the accused, Guru Halu, has assaulted the victim with punches and kick.
Hmm.
It is a fact that the accused did not wanted to hide the incident, or else he would not have called Pradeep Chatia P33.
Hmm.
I come to know that the lock had 2 keys,
Hmm.
out of which one is with the landlord and one is with the accused.
Hmm.
I do not know whether there was a 3 keys, but Mamoni Roy Basunia has told me that sometimes the victim used to call her and pass over the key under the door, and Mamoni used to open the door. I have not seen any of the keys. It is a fact that the landlord told me that when he met the accused at around 22 hours of 9/7, the incident was 8, my lord.
Hmm.
Incident was happened on night of the 8th, my lord.
Hmm.
9/7, and asked not to quarrel. Then the disease was not injured, my lord.
Hmm. So 22 hours means 10 o'clock.
10 o'clock,
10 o'clock at night
Yeah.
on 9/7.
9/7,
They spoke and then she was not injured.
not injured. And as per the FIR, as per the investigation, my lord, incident was occurred on 8th, my lord.
8
8 of the night, my lord.
and 9, she was found all right.
All right, my lord.
No, there is some mistake here. When was she found dead?
On 9th, my lord, 9th of evening, when the accused came back to the enter the house,
Hmm.
and he found the disease was unconscious, so she
9.
9th, my lord, 9th itself, man.
Then you
Evening.
said 8.
9th of the evening.
Ah.
And all the witnesses say, I heard the quarrel on 8th,
Acha, the
And-
quarrel was on the previous night.
previous night, man. And doctor also says
And this case relates to circumstantial evidence.
circumstances, man, all circumstances.
Just show me the FIR.
Yes, ma'am.
If he has a very strong case,
Yes, Your Lord.
then we can
There are-
consider.
There are substances against him, Your Lordship.
Acha. Okay.
FIR is page 18, my lord. My lord will find 5 copy at page 21, my lord.
Page 18.
Page 18, start from page 18, my lord. 5
Hmm.
copy is at page 21, my lord.
Yes.
It is to inform you that
Naku Tango is who?
the informant, my lord, is the
Sis-
brother of the disease.
Huh?
Nakotangu is the brother of the disease.
Brother of the deceased.
Yes, ma'am.
Yes.
It is to inform you that on 9/7/2024 at around 9:40 p.m., I received a call from relative from Zero informing me that my sister Nako, as a 30 years daughter of so-and-so, Zero Lordship University, has been brought dead at Trims, Nalagon. The emergency doctor has said that she was brought dead by Sri Guru Halu,
So
accused.
9:40 he got the information.
Yes, and he was informed by this accused himself, my lord.
From a relative, but from a relative informing.
FIR, in FIR, he says
Huh.
relative, and in deposition, my lord,
Acha.
and before the court also, my lord, he says it was informed by the accused.
Okay. The emergency doctor had said that she was brought dead by Kuru Halu.
Yes,
He is the accused.
accused, my lord. Which indicate that she was brutally beaten till death by the accused Sri Guru Halu. Since the accused is currently in your custody, I request you to kindly register case on trial.
Numerous bruise marks.
Yes, number is Bruce Mark, my lord.
Brutally beaten dead. What is the PM report?
PM report says, due to internal bleedings, my lord. Due to
Shock and hemorrhage resulting,
Ah.
Your Lordship, internal bleeding.
internal bleeding, my lord.
So because of
Shock,
assaults,
yes.
Because,
not strangulation.
no,
वगैरह.
no,
no.
no weapons, nothing, my lord.
So there were numerous bruise marks.
Yes.
Doctor, my lord, I also
Hmm.
clearly not
Since it-
understand, doctor,
Acha.
doctor, my lord,
Doctor
fine.
is yet to be examined.
Yes, my lord.
Then,
Postmortem report is, my lord, start from,
Your Lordship will see at page number 50 is the
yes.
opinion of the medical
Hmm.
officer.
PM report.
Yes,
PM
my lord.
report.
50, page 50 is the opinion, my lord.
Page 50, yes.
And my lord, regarding Jewish mark, my lord,
Wait,
it is
one
page
second.
48, my lord.
Wait,
48, my lord.
the medical report starts from
It starts from
48,
47,
47.
47, my lord. And my lord, 48,
Inquest report says what?
uh,
Multiple bruises
multiple bruises, my lord.
all over the body.
Yes, no, no. Yes, my lord. 48, my lord.
Hmm.
Kindly come to the 48. Is the injury, my lord? Bruise mark regarding bruise mark, my lord.
The dead body was brought on in 9:15 on 9/7 itself.
9/7 itself, my lord. On 9/7, the
Hmm.
accused was whole day at
9/5 or 9/7. What is
9/7.
the date?
9/7, my lord.
Acha.
Page
Bruises on right elbow,
yes.
right what? Brow and eyelid.
Multiple small.
Multiple small
Bruise
bruises
was chest,
all over
abdomen,
chest,
back of trunk.
abdomen.
Multiple bruise on both the upper limbs and lower limbs as we are ranging from so and so. Whether this
So the fatal blow is that chest, abdomen.
Yes.
Back of trunk, before that, what is that word? Multiple small, 0.5 into 0.5 centimeter.
yes,
Two. I'll see the original.
whether this injury in ordinary course, my lord, it will cause death or not, my lord.
Like back of trunk, in back of trunk,
Multiple in back of trunk, my lord, yes. It's like trunk.
trunk, spine. What is trunk?
I don't know.
But
Okay.
these are small bruises.
Small bruises, yes.
The fatal harm is Ginny.
Yes, Your Lordship.
See the findings. Bruises on right brow and eyelid will not lead to death.
No, it's
Small-
just an exterior finding, Your Lordship.
Acha,
Your Lordship will
exterior
say,
finding.
yes, Your Lordship. Your Lordship, if Your Lordship will come to page number 50, Your Lordship, this is the conclusion of the
Resulting in blunt trauma to the chest and abdomen.
yes, you know.
Oh, the injuries that were considered fatal is chest. So page 50.
50, Your Lordship.
Cause of death was. due to
Lordship will
stroke
see the
and
cause of death was due to shock and hemorrhage resulting internal bleeding,
Hmm.
resulting of blunt trauma to chest and abdomen, homicide in nature, Your Lordship.
But see the chest and abdomen, those are small bruises.
Yes.
No, that's only the exterior part, Your Lordship. If Your Lordship, someone punches, Your Lordship,
Hmm.
some of them does not even have bruises, Your Lordship. This is when the
Hmm.
how the internally it has been
Hmm.
damaged, Your Lordship. That is what's to be
My
considered.
lord, that will be.
That should have been also
Uh,
reflected in the postmortem
yes.
report.
Yes.
That internal thing, where is it? See stomach and what? Chest.
Chest.
Where is that chest and stomach?
Page number 48.
in my- Multiple small bruises.
Correct, abdomen. Abdomen, it is written. 2 liters of blood present, congested, lacerated present. What is this? Necrotic liver. Liver and bladder. So in the abdomen, laceration is there.
German, yes.
Inside laceration, inside the liver. And what about chest? Did you find chest somewhere?
Only the external finding,
No, in the chart. Internal appearance. In the internal
stomach.
appearance column, where is chest,
Yes.
walls, ribs and cartilage?
My lord, chest is not.
Fracture of ribs.
Just
Fracture of ribs is there. See, in the internal appearances,
Yes.
fracture of ribs. And to the chest wall, what is written there? Adherent. This doctors also have good handwriting. Yes, not true. Adherent or what?
Chest wall. Adherent to chest wall. Chest wall. This is
Chest wall.
with regard to right lungs and left lungs, Your Lordship. Either not.
Abdomen.
I don't know because even the if
Acha,
If
ribs
it-
are fractured.
if it's-
Then, Mr. Okay, medical report is this. Now show me this, the deposition of some
Yes,
of them.
yes, yes. And the position, my lord, start from page, my lord,
Which is in
56.
favor.
56, my lord. Page start from 56.
This is not a criminal appeal that I'll go to each and everything.
Yes, ma'am.
Show me whatever is in your favor.
Yes, ma'am.
Who, number one is, he is who? Doctor,
Informant. ma'am.
informant, Your Lordship.
oh, he is the brother.
Brother.
Yes, oh, he is a hearsay. Then,
PW2 is an important witness, Your Lordship.
Yes.
two is?
The rent owner, Your Lordship.
Rent owner, madam.
Acha.
He is also contradicting his earlier statements, my lord.
Used to stay with a girl. So this, they stay together in a rented room, right?
Mm.
Hmm. Michael is the very accused.
Accused, madam. I have seen the dead body.
Your Lordship, if I may read, Your Lordship.
Uh-huh,
If I may read the relevant part, Your Lordship.
yes.
If Your
During
Lordship,
the month of
yes.
July, they
Ju-
stayed together. During the night of 8th July, there was a quarrel.
Where?
Yes. At 8 p.m., there was a quarrel
Mm.
between the accused person and girl who stayed with him. Then other tenants informed me about the quarrel. I went to PO and I have consoled the accused person, asked him not to quarrel and make noise. It will disturb the neighbors as rooms were kacha and the walls were made of tin.
Hmm.
Thereafter, I went back to my residence. At 10 a.m., that is the next day, after dropping my wife, I came to tenant premise, met the accused outside and asked the accused person not to quarrel as the same will disturb the other
Hmm.
tenants. During that time, the accused person told me that he is in urgency and he will go to Assam by saying that accused went away by riding a scooty. Your Lordship will then notice the rented room of the accused person was locked from outside from morning to evening at about 6:22 p.m. I have made telephonic call to the accused person and asked about his whereabouts. I told the accused that after the quarrel during the night, he went away by locking the girl inside. She might be in urge of natural call. After I made the call to accused person, he came to the rented house, but I was at market. On the night, police came to the rented house premise with Michael and checked the rented room. However, there was nothing. Now, this shows, Your Lordship, that on the previous night, there was a
Mhm.
quarrel. Next morning, on the same night, he has suggested them not to quarrel.
Mhm.
Next morning also, he came and told the accused not to quarrel. The accused informed him that he need to go to Assam, Your Lordship.
Yes.
Thereafter, he locked the house from
Wait,
outside.
that night, okay, he told them not to quarrel at about 10 p.m.
At
Huh,
10 a.m. That is the next day, Your Lordship.
10 a.m.
Yes.
Ah,
After
okay.
dropping my wife, I came to tenant premises, met
Hmm.
with the accused outside, and
Then he left for Guwahati.
then he left for Assam, Your Lordship.
Acha. At 6:22 p.m. Bapre, he remembers even 22.
Yes, the rented
I
house.
have made telephonic call.
Yes, since the room was locked from morning, Your Lordship.
Ah.
He made a telephone.
With the landlord.
Where he
With the landlord.
And somewhere
then-
you had shown she used to pass the key and.
Yes, yes, yes,
Ah.
madam.
I made the call to accused person. He came to the rented room, but I was at the market on the night. Police came to the rented and checked that there was nothing. Means the body was not there.
No, that is when the accused came back. Your Lordship will see that argument happened on 8.
Mm.
On 9th morning, he visited the accused at 10 a.m., Your Lordship. Accused went to Assam, Your Lordship. He called him back.
Mm.
This accused
Me-
came back, and when he came back, there is another statement of other person, Your Lordship. When he came back, that's when he took the deceased to the hospital, Your Lordship.
Mm.
Thereafter, FIR was filed, Your Lordship. Then the accused was brought by the IO to the PO, Your Lordship. This line reflects that
Oh,
incident,
acha.
Your Lordship.
My lord, days 74.
So I made the call to the accused person, he came to the so-and-so.
Yes.
So in the meantime, he took her to the hospital.
Hospital.
And on the night, police again brought him to his
Yes.
home.
I'll just take Your Lordship to PW3's statement, who went to Assam along with the accused on that day, Your Lordship.
And what is the cross? I went to the rented room. I did not see any injury. When I went to the rented, there was argument between them and I have not seen any physical assault.
Yes.
I have not seen any injury on the person. This he talks on
Previous night, Your Lordship. 8, Your Lordship.
I do not remember as to whether I have seen the deceased. I do not remember as to whether I have seen the deceased. Whether I have seen after Michael left. They stayed in the room before the day. I have not heard any quarrel. Before the incident, I do not remember.
Yeah, he retract from the 161, my lord.
It's okay. The materials that can be taken from this witness is that there was a quarrel.
Yes.
And on the next morning, she left. He left.
Yes. And
And
Your Lordship
then
will,
at night,
Your Lordship will also see that the more specification that he has locked his room from outside, Your Lordship. The whole day he was not there. When he called back, Your Lordship, that's when the accused took the girl to the hospital, Your Lordship. Now, if I may take Your Lordship to page number 16, which is the statement of PW3, Your Lordship.
16.
16.
60.
60, Your Lordship.
60.
PW3, Your Lordship.
Who is he?
He is the one who went along with the accused to the to Assam, Your Lordship, on the next day. That is on 9th, Your Lordship. If I may read, Your Lordship, I know the accused so-and-so, he is so-and-so and properly known as mine. Before one day of incident, I along with Rajan Praveen went to pollution test office. Thereafter, we went to the shop near Chandini Hotel. During that time, I have received phone call.
Someone else, Rajesh Parbin.
No. This
Before
is
one day-
Pradeep Chetia.
No, yes, he talks of some Rajesh.
No,
Parbin.
thereafter,
Acha.
Your Lordship. Thereafter, we went to the shop near Chandni Hotel. During that time, I received call from the accused. I was told the scooty of the accused, which was new one, has damaged due to accident, and on the next date, he wants to go to Lakhimpur. I was asked to accompany him. I told that I'll accompany him next day. That is on 9th, Your Lordship. Next day in the morning at 8 a.m., I have received call from accused asking me to get ready to accompany him for going Lakhimpur. At about 9:30, 10 a.m., I along with accused person went to TVS dealer at Lakhimpur, asked for the part. We were told that the part was not available with them. Thereafter, we went to TVS dealer Lakhimpur, but we could not find spare parts there also. During the time, I have received one phone call from one of my friend who was at vehicle service center at Bagitinali. I was asked to assist him in driving his car as he do not know driving and asked me to call him when we reach Bagitinali. Thereafter, we tried to reach the spare part in other available shops at Lakhimpur. We have found these spare parts at local shop and we have repaired the scooty of accused person and thereafter went to have lunch. I along with accused person reached Doimuk through Gumto. On reaching Doimuk, I called my friend as to whether he needs my assistance for driving his car and informed that I reached Doimuk. He told that
required these things. Okay, it proves that he went away.
then importantly now I'll come to that, Your Lordship. He told that he has taken the car. We sat for nearby the river at Doimuk and we discussed about wave of river and accused search the reason on his mobile through Google. At Nahalagan, I have purchased some goods for shop and accused person have purchased some momo for his girlfriend and after dropping me, he went to his residence. It was about 7 p.m. in the evening. Thereafter, 9th, Your Lordship. Thereafter, I was again at my shop as my mother went for preparing dinner. At about 8 p.m., I have received one call from the accused. He told that his girlfriend is unconscious. He asked me to come with our car to take his girlfriend to hospital. As there was customer in the shop, I could not come immediately. However, after a while, I came to the rented house of the accused person with my car. When I was at my car and informed the accused that I have reached, the accused has brought his girlfriend on his shoulder. I opened the door and the accused was made his girlfriend lie on the back seat. Thereafter, we proceed towards hospital. While coming to the hospital, I was told by the accused person that his girlfriend used to drink a lot. I was also told that accused had some argument with his girlfriend. I do not know whether the girlfriend of the accused was alive, but she was not talking. At Trims, when the accused person was trying to take out his girlfriend from the car, one girl was nearby, assisted the accused and brought one stretcher and the girlfriend was taken inside the hospital. I was waiting at my car park. Your Lordship will then come to the cross of the defense, Your Lordship. On the day of the incident, from morning to evening, I was with the accused person and we went to Lakhimpur, Assam. During the day, I have not noticed any abnormal behavior of the accused. I have not noticed the accused person receiving any phone call from any person. I have not noticed as to whether the girlfriend of the accused was unconscious or under influence of alcohol while she was kept on the back seat of the car by the accused. I was told that argument between the accused and his girlfriend took place on the previous day. Now he was, your lordship will see that on the day of
All day.
When-
That is not disputed, my lord.
But then
But-
he came back 7 PM from,
Yes.
there must be a quarrel again, he hit him.
No, no,
There is a
on same,
possibility.
on same day, there was
What-
no quarrel, my lord.
what I'm trying
Other
to,
witness also says on the same day and same rent, who were staying in the rent also, they said last night only. it
Okay,
was-
last night, but then on being informed by his neighbor, he came back.
Ah.
He reached his house at around 7.
Yes.
And thereafter, something must have happened. But then his presence is not denied. He was with his wife at the relevant point of time.
yes, your lord.
On 8th, yes, he was. with her.
On 9th also.
On 9th also.
Night,
Because when he came back,
on
then
the
it,
day, on the day, my lord.
The way you reacted was so funny. 9th also, because 7, he said it was 7 PM in the evening. And then at Naharluk, and he, after dropping me, he went to his residence. It was 7 PM. So 7 PM on night, he reached his residence. His wife was already there.
Yes,
Huh.
yes.
And then thereafter at our shop at my mother, at about 10:08, after 1 hour, he got a phone call that his wife was unconscious.
Yes.
So that 1 hour period, they were together.
Yes.
Now there is no report of quarreling at that point of time.
Yes.
But then his presence with his wife is established.
Yes, my lord. Also one witness.
And then he brought her.
Who saw that.
It can be a case of 304B. It can be a case of 304 part 2.
Part 2, yes, my lord.
Yes.
It can be part 2, yes.
Can be a case of 304B, I'm
B, yes.
mistaken. 304 part 2.
Part
Okay,
two.
there was a quarrel and between, they are in relationship and then
That's part I
he
also,
hit-
also
he
agree.
hit her. Ribs got fractured. There was internal bleeding and she died. That, of course, the circumstances has to be again proved.
Yes, yes.
Chain has to be complete.
Change, yes. to be
at least
complete.
at this stage, your lordship, there is prima facie case against him, your lordship. There are two witnesses who clearly testify that on the first night there was a quarrel, your lordship. Next day, while he was going, he had locked the door, your lordship. It was only upon his call, he came back and unlocked the door of his room, your lordship. The same testification also been there by the PW3 that after they were separated, your lordship, he went back to his house.
Regular routine.
Thereafter, he called him up saying that his girlfriend need to get to the hospital and she's unconscious, your
My
lordship.
lord, may.
Now, your lordship will,
PW10, my lord.
Hmm.
Please may come to the PW10, my lord. Locking of the
74.
door is my routine.
You said,
Yes, my lord.
which part?
My lord, we start from second para, my lord, on. See, my lord, on page, come to the page 75, my lord.
Hmm,
From the top, 1, 2, 3, 4, 5, deep line, my lord.
hmm.
Sometime.
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 Accused used to go away.
Yes.
Accused used to go away after locking the door of Asha from outside.
Yes. Sometimes Asa used to call me to open the door when she used to attend natural courseman.
Mm.
These are regular routines, man.
No, regular
It is-
routine, but you see the chain. Chain will be like this. They were together, they had fought on the previous night.
Yeah.
There were reports.
Yes,
Then morning he went out
yes,
and then he came back at 7.
yes,
From 7 to 8, they were together. 8, he informed his friend that his wife is unconscious.
yes.
They take her to the hospital.
No, was
And
not
hospital, she was found dead.
my lord, death of
And the
the
brother.
death of the disease was 24, my lord. 24 hours, my lord.
Where is the time given? Approximate time of?
24 hours, my lord. 24 hours, my lord.
Where is that?
If I my postmortem, my lord, will find it postmortem.
Fresh at the time of death, age of injuries, fresh, more than 24 hours.
More than
Okay,
24 hours, my lord.
Okay, more than 24 hours, that she must have been dead on 8 itself.
it-
Yeah, it is
because
definitely.
there are many neighbors who testify that during that night, they heard the victim shouting in pain, your lordship. There are other witnesses also. Now, your lordship will also consider with regard that There is no witness who says
But
that
then
on the
there
other
are
date.
evidence against you.
Yes, my lord.
There are, oh, you admit, yes, there are evidence against you. But at bail, at this stage,
So, my lord,
I
for
don't
ground
think
for
so.
the bail, my lord. I'm in custody for more than 11 months, my lord. More than 11 months. I've been,
See, I have to do justice to accused. Accused person is innocent till he is
yes,
proved.
yes.
But I have to be justiciable to the society and to the victim as well. So I'll think over.
My lord,
I'll pass the order in the
my lord, from
chamber.
yeah, my lord, yes. I have one citation from the Jaipur High Court.
Mm.
Sir, my lord,
Acha, what were your submissions? You said,
grounds to my submission is, my lord, I think,
just give me in brief
oh,
your submissions.
custody for more than 11
Ah,
months, as up to the 11 months and 15 days, my lord.
mm,
And there is no chances of hampering and tampering of the evidence.
mm,
Most of the prosecution witness has been examined.
mm.
And if he be released on bail, my lord, he will get chance to prove innocent, my lord.
Mm, mm.
And my lord,
Still he has chance to prove his innocence.
yes. And there is no chance of playing
Absconding.
justice, my lord, yeah, absconding, my lord. And he belongs to the
On
innocence-
merit? What are your submissions on merit of the case?
merit, my lord.
No chances of conviction.
Conviction, ma'am.
What are the grounds for that? That
The positions of IO
that he left. The
Yeah.
quarrel was
on air.
on 8. And you showed somebody who said
So are you-
no injury. Are you?
Cross in cross, my lord.
The
And
statement of IO has not been given.
PW2, PW2 itself says when he went to the quarrel spot, my lord, he did not see any injuries on the deceased body, my lord.
Where is that? Where is that? Acha, acha. That is 161 statement.
Yes.
Right.
Yes, my lord.
Landlord.
Landlord, yes, 161 statements, my lord. And my lord, there is no any criminal incident against the accused, my lord.
Hmm. Okay, these are all what judgments?
My lord, judgments.
And you have placed the,
My lord, this is of the Rajasthan High Court of 1982, my lord.
acha, okay, High Court.
Yes, I.
Acha, what were your submissions? Just give me in brief.
Your lordship, my submission is that at this stage, your lordship. when
That
the-
is there.
That is there, your
Hmm.
lordship. And the only reason that he can seek for is that it was no fault on his part that the trial is being delayed, your lordship.
Hmm.
That part. Then PW2 statement, your lordship.
Hmm.
There PW3 statement, your lordship. And also,
PW1 you did not, right?
yeah, because one is
PW2.
just an informant who received the dead body. Yes.
PW2 statement, okay.
Yes, sir.
Dropping and all, he came back at 7 and all, okay.
Yes, sir.
Then, these
Then-
are all?
PW3, the person who has taken him, your lordship.
Ah, yes, PW3. Hmm.
I would also rely upon the MLC, your lordship, because the reason that was given that he's informed his friend that his girlfriend takes alcohol, your lordship. In the
Mm.
post-mortem report, there was nothing found, your lordship. And one of the main point is that, your lordship, even in their cross, your lordship, or none of the witnesses has even stated that after 8, that is the next day, anyone saw the victim coming out of her house, your lordship. And all the witnesses has stated that on the previous night, they could hear the victim shouting in pain, your lordship.
Hmm.
The statement of the all the witnesses, timing is not there.
Hmm.
Some says on 8 p.m., some says 2 a.m., some says 10 p.m.
Now, this timing you must have seen in Supreme Court judgments.
Yes.
It can differ.
Differ.
Because village people are not in a habit of remembering the
Yes.
time and be very cautious about. So time might differ.
Your lordship, I'll just take Your Lordship, to page number 67, Your Lordship. A small, this, Your Lordship. Your Lordship, this is the deposition of PW6, Your Lordship.
Yes.
It starts from the fourth line, Your Lordship. It starts on the night 8/7/2024 at about 10 to 10:30 p.m. There was sound of shouting and quarrel from the rented resident of the accused person, for which we were not able to sleep. I have heard sounds of crying by the lady who stayed with the accused person on the same room. During that time, the landlord came there and asked not to make any noise, and thereafter we could sleep. On the next day morning at around 9 to 10 a.m., the accused person went away from his residence after locking the door from the outside. Your Lordship will see, I have not seen the girl for the entire day. So even on the night, if the postmortem report states that it was a 24 hours, this substantiate, Your Lordship.
But then the person who accompanied the accused while
Yes.
they took her to the hospital,
Yes, Your Lordship.
he did not say, because if a person dies around 24 hours back, there will be some changes in the body. He did not say anything.
He did not say anything. He just said that she was not talking, Your Lordship. However, if Your Lordship will see, the
Was normal, my lord.
40, page number 45, Your Lordship.
Accused was normal.
40
Accused went and then came back.
45, Your Lordship. The person was already brought dead, Your Lordship.
He was brought. She was brought there.
Yes.
My lord.
He was not on bail during. Oh,
No, 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 my. I was not in on bail, my.
No, he is inside since the day of his arrest.
Yes,
No bail at all.
no.
Okay. I'll think of and I'll deliver the
Yes, sir.
judgment in the chamber. I have not decided yes of yet, but. And what about your judgment which you had given
No,
this
Paragraph 5, my lord.
Rajasthan?
Yes, Rajasthan, my lord.
But paragraph 5.
Yes. From this trial court of execution, evidence has been closed and argued by the learned counsel for the petitioner. There is no question of tempering, hampering the prosecution evidence now. It is also admitted that the case is now fixed for recording the statement of accused, and then the evidence will be taken up, and therefore the case will be heard finally. Though it is a murder case connected with dowry, but I feel that after all, the accused be also provided an opportunity to lead evidence and to prove his innocent. I further feel that one of the accused persons should be released on bail, and so that they may be able to face the trial and lead evidence if so.
Okay, Your Lordship, I'll just place, if Lordship is, this Kalyan Chandra Sarkar, Your Lordship, which deals that as
No, you had given one judgment.
incarceration.
Such late bail should not be allowed.
Yes, Your
Is
Lordship.
that
Uh,
not the file, it seems? Wait. I had taken it that time.
Your Lordship,
Can you give me again?
yes, Your Lordship.
Sorry, I have to take
Please,
it for
Your
second time.
Lordship.
Okay.
Kalyan Chandra, should I place, Your Lordship?
Why Kalyan case?
Which says that in this case, accused has approached the court for the sixth time for bail, Your Lordship. He was already in the custody for 3.5 years, Your Lordship. The reason for him was that he was in incarceration for 3.5 years. The court stated that that cannot be a sole ground for
bail. Okay, give me. What is the para?
para 13, Your Lordship.
Paragraph 13. Okay. Okay, I'll try to deliver it as soon as possible.
Item number 19, Lordship.
Acha.
Just this matter can be posted for admission hearing, Lordship. Like, Lordship.
Orders.
Orders, Lordship.
More matter to hear it too. You'll not stay back at.
Lordship, I have a.
Okay.
I have some.
19, right? That on the prayer made by.
J. Gini, Lordship.
Huh?
J. Gini.
J. Gini.
For the petitioner.
Appearing for the petitioner. Let the matter be listed after.
After break, Lordship.
After the summer vacation.
Summer vacation.
After 3 weeks.
I've taken the consent also, Lordship.
Okay. Keep it. 2 o'clock I'll again hear it. To the chamber. And with this sheet also. With this sheet. Okay. Thank you. Yes. Your matter. Hmm. You have seen?
Yes.
Ready?
My lord, before going into the merit, my lord, may kindly peruse case number 22.
22. Yes.
My lord, case number 22 is epidemic.
Hmm.
This one shown by someone else. I see so and so, so and so.
He is the deputy commandant?
Yes, Deputy
Yeah.
Commandant 24 Assam Rifle Longling, in which place the petitioner were posted at the time of the incident.
This,
And
yeah.
as such, I am fully converted in fact and circumstances of the case. Now, my lord, in any case, my lord, criminal case, accused on behalf, accused cannot authorize other person to swear affidavit on his behalf. My lord.
And
So,
that too, he is swearing on behalf of all the four.
all the four. And
But
authorize,
he has not clarified also.
not clear.
The petitioner.
Authorization letter is-
Where is that authorization?
Authorization letter is from page number 58. 58.
Yeah. 58,
Yes,
okay. I, Major Pratik Dabas, one of the petitioner in Dinter, to authorize Jairam Singh to sign in the affidavit on my behalf.
POCSO is signed by the.
No, this is not a civil matter or some other contractual or where the an authority can represent.
I think I was aware of advocate should not step into the shoes of the client. But this is here another officer is authorized to file on his behalf. But there was no requirement. If somebody is inside the jail, okay, he can authorize. But then he is outside, he.
Yes.
So they're from different place, man, so it is not, this gentleman is here.
Otherwise, man, affidavit can be also sent there and they can swear respective
That
persons
can
and
be-
take that.
From different place, man, the problem is this.
My lord,
Doesn't matter different place. It can be sent to them and.
That is- Yes, yes. But there is authorization.
But this is not a proper way to file the affidavit.
my lord, I have serious objection, my lord, because epidemic, the accused person had to only swear the epidemic. No, he cannot authorize some other person to swear epidemic on his behalf.
What I can see is they are not acting properly towards court. See, they have not appeared in so many dates in spite of being called.
My lord, that is, that is different, my lord.
Again, he did, they don't swear the affidavits.
I'm coming to now, read the petition.
Hmm.
What about this? My lord, the lord.
So, my lord, my-
Your lordship, the object that is, the inquiry report from this, my lord, from after the PI, PI after the PI. The public litigation interest file, my lord, this inquiry report, my lord, what inquiry report says. This, my lord, and another thing is, my lord, this, if one person, my lord, against whom cognizance is not taken, my lord, and search it also says, my lord, I'm coming to search it, my lord.
But he is on the preliminary
Yes, my
ground.
lord, I'm entering to this very petition, my lord. So this, my lord,
Maybe.
Do you have any judgments? Do you have any judgments in support of this swearing not being very proper?
my lord, to my humble understanding, accused person cannot authorize some other person to swear. Of course, judgment that I can, but in that matter, my lord may take up the matter tomorrow.
Because I know those judgments where lawyers should not do, but other people, and when they are out,
I am not, I
My
never
lord, this is
come
not
to
the case where the accused person is
I-
inside the
I
jail.
never come.
inside the
This is
jail,
okay.
then.
Inside the jail, they can authorize.
My lord,
He is not in the
jail
jail.
or my lord, what is the difference?
My lord, this
If
is
my
quashing
friend
petition,
plays
my
a
lord. This
judgment,
is
my lord.
quashing
We are
petition.
saying, my lord, it is not sufficient, my lord. When he's objecting a affidavit, my lord, it has to be with his some decision, my lord. We are saying this is the case, it is not, my lord. This morning time, so it is shown, my lord. Here, what happened, my lord, this way of this,
No, one thing is that in this petition, you have challenged the cognizance
cognizance.
on the ground that no sanction.
Cognizance as well as there's this, it is what.
That is a bailable warrant.
Yes, I am.
That is not NBW.
Yes.
So he can
But
come
search
and
it-
then he will be.
Search it as well as the cognizance. Without proceedings, they cannot, take cognizance, my lord. And so
No,
far-
that is correct. Okay, we will
And
have
so
to
far-
see
so-
whether it is in the official duty.
Yes, my
Of
lord.
course, prima facie, it seems it is in the official duty.
Yes, my lord.
But there is no urgency. What I want to say is there is no
What happened-
urgency.
My lord, what happened is because of this, even sanction, my lord, only for that, my lord, because at that time, our sports special activity, there, my lord. And so far, the old act, my lord, your CRPC 197,
Yeah.
my lord, this, especially this protection is there, my lord. When there is protection, my lord, in our sports special act section 6, my lord, this protection is there. And so far, my lord, 91, 97, this protection is there, my lord.
No, these are there.
So there.
But what I want to say is there is no urgency. Let
Yes.
him go through. Let him bring some judgments in his favor
And-
that this kind of conduct is not proper.
Yes, ma'am.
And as far as your apprehension is concerned, that
My lord, there is a.
bailable warrant,
Next day-
you go and appear and you will be given bail.
It's difficult. Problem is then, so before this honorable court, madam. In other, I am placing before the.
Difficult for whom?
My lord, I'm placing one judgment, my lord, this relating to my lord, this. If my lord is, I place before this now honorable court, my lord, this same thing, my lord, regarding prosecution sanction, my lord. The our high. court-
Prosecution sanction, I'm okay. I'm
Yes, my lord,
satisfied.
and why I will appear before it now, the court below, my lord. Because the court below, the competence, it was not as per law, my lord. Moment is this, it is not as per law, why the accused will, appear before this honorable court and, pray for bail.
But why he did not
Yes.
appear before the court on
Yes.
other dates?
My lord, so my lord, thereafter, my lord, initially, the subsequently, the way I am engaged, my lord.
Hmm.
Initially, it was, my lord, it was, may not be done, even proper advice to them, my lord. Because the moment, my lord, the initiation and prosecution, we start, my lord, cognizance taken, it is bad, my lord, as per law, my lord.
When was the cognizance taken? Just show me.
Yes, ma'am. Cognizance taken, my lord. Cognizance taken, my lord, on, 5/6.
Where is that? What is the page number?
53.
53.
And my lord, this without application of mind, this, the cognizance was taken, my lord.
Wait,
Nothing is there.
53.
Yes, ma'am.
Charge sheet against the Iman. Pratik Jaspal will be appearing under 304. This was taken on 5/6/24.
Yes, ma'am.
And when is the BWA order?
PW, my lord, when my junior appeared before its honorable court, my lord, particular court, my lord. And this on 23/2025, my,
What is the page?
PS 57.
57.
My lord, thereafter, my lord, this only, my lord, this.
Huh. This is on 23/25.
And-
See, from 5/6/24.
There is another, 3 order, my lord, okay. My lord, this 5/3/24 is one order, my lord.
Mhm.
5/6/24 is one order, my lord.
Hmm.
Thereafter, another order is, my lord, 55, my lord. 13/8/2024, my lord.
Mhm.
13/8.
55. Okay,
55.
13/8/24.
Hmm.
This is secure currently in JNK and is informed that to
Yeah,
him
from
that
another,
PIL is pending with regard to the same issue. This has a date of appearance. This will be placed for another case, so and so, are absent without steps. Pratik Abbas,
Yes.
there is an appearance.
and thereafter, my lord.
Pratik Abbas is also an accused. Pratik Dabas,
Dabas, he is, my lord, yes, ma'am, now he's measure, initially he is, my lord, initially he was, my lord, captain, my lord. He was, earlier, my lord, and DHA, through DHA, he entered, yes. And thereafter, another date, my lord, 27/11/2020.
and summons were issued, rightly so. Then
Yes.
Then, my lord, 27/11/2024.
rejected.
Another date.
Dispense application rejected on grounds it's not supported by any official documents. Issue summons. Again, summons issued.
Yes, ma'am. And-
On
and
27/11.
Thereafter, my last.
In all proceeding, they did not appear
23/3/2025.
from beginning.
Their BWA. No, what I want to say is, see, cognizance was taken on 5/6/24 and you have not filed any petition.
My lord, it is not ever back because it was not communicated to them.
That is not a valid ground.
This is not, they know about the FIR, they know about the
Not even then,
charge sheet.
even then, my lord, when this, the cognizance was taken wrongly, my lord.
That is
And-
not, we have not implemented.
No, whatever, they have to challenge this order that no good sanction. Now they are, you have filed the petition when? You have filed the petition now.
Yes, madam.
This is on 29/1 or what? When did you file the petition?
My lord, this on, my lord, this, we file on this
This is this year.
18.
See, and you have only, I mean, you have filed the petition only when this BWA was issued. And you were scared, now you are taking that ground.
My lord, my-
And over this
my-
one
my-
year,
my lord,
Yes.
immediately.
more than 1 year,
Yes.
they have not filed.
Yes, madam. But even then, my lord, when prosecution,
Hmm.
without, my lord, prosecution sanction, my lord, India, charge sheet also, my lord,
Hmm.
page 50, my lord,
Hmm.
page 50, charge sheet, my lord. Page 51,
Hmm.
last page.
Yes.
How in the court below can take cognizance, last line, on the basis of investigation, a primary case is well established against the accused mentioned in CS column so and so, so and so, so and so, 1 to 5, under section 304 to 26, so and so, so and so. Since accused involved in incident case are serving army personnel, hence an application has been submitted under section 197 CRPC
Hmm.
to the Minister of Defense, Government of India, the through the Home Department, Odisha Pradesh for a record of prosecution sanction against 5 persons. However, prosecution sanction against them are pending.
Are pending.
It is before this court, my lord. How court can take, my lord, this cognizance, my lord? It is barred, my lord.
No, whether that is legal or illegal, that we will examine. But the thing is, you are very late in challenging the cognizance order. When is the charge sheet submitted? It is 4/12/23. Charge sheet is submitted 2 years back. And then when you are issued with the BWA, you woke up and then you filed.
And my lord, is when they for prosecution section January 2023, my lord. They wrote letter to the Ministry for prosecution.
Okay, that is pending. That
My
can
lord,
be
One.
wrong. But then you are very late in coming. Only when this BWA, you woke up and you have filed this application.
My lord, this,
Yes.
when we are, my lord, at that time, my lord, the situation of the.
And my lord,
This Ruby is not good, my lord. So, my lord, this.
That- But then,
My lord, that was request to take time for appearance, my lord, on that particular case. When my
no,
junior
but then
appeared.
see, okay, situations are not good and all that. But then see their conduct. Were absent without any steps. Summons were issued. Again, on the next occasion, they were without issues, without the dispense application they have filed, but without documents.
My lord, the lawyer appeared, my lord. The lawyer appeared, my lord. Initially, my lord, the 13/8/2024, council, Mr. M.
For only protect the bus.
Yes, my lord. And my lord, they have not received, my lord, that is not reflected, my lord, whether they receive or not, it is no whisper, my lord.
And my lord, one thing, my lord,
Hmm.
since this is a quashing petition, my lord.
Hmm?
Since this is only a quashing petition, my lord.
Hmm.
And my lord, this valuable BWA is yet to be executed also, my lord.
BWA, he
Yes.
need not
Yes.
afraid of.
Yes.
He can go, bail will be
Yes,
granted, he
yes.
will
So-
appear.
That's why.
So,
BWA is also yet to be executed and he
I
has to appear.
understand, but.
had it been NBW,
My lord,
okay?
My lord, I have placing one.
And they have not challenged the BWA also.
My lord, this, the order, yes. Tell us.
No, there is no such prayer.
Yes. Yes, dear. Page 20. Page 20, it is there. Imperial order dated 5/6/2024, 13 and 23 to 2025. It is there.
No, why I am saying you all this, Mr. Medhi,
I understand.
is that let him go through, let him bring the judgments on the preliminary ground of challenge. And then the petitioner should come and appear tomorrow, and then we will hear this
My lord,
petition.
I'm placing one judgment on order of this honorable court where I appeared, my lord.
Mm.
And in subsequently, the RK Deputy appeared before.
If it is on prosecution sanction, you need not, because it is a settled position. Without prosecution sanction, cognizance
Yes.
cannot be taken. Unless
Yes.
the court is not very sure whether it is required or not. Then at any stage of the trial, it can be. Okay. Now here, we'll have to see whether it is in the discharge of official duty and all.
Yes.
Prima facie, okay, it is in a discharge because people were pelting stones and he had no option, he has to
Yes,
fire.
yes.
But then before firing, there should be other methods to be adopted by the army
Whether the firing
personnel.
was necessary or not.
Necessary or not, that has to be again
Yes,
seen.
yes.
So when the judicial inquiry report is before your lordship, if lordship allow me, I read in two petrol.
No, this will be again going into the
Yes,
merits.
yes.
Let us decide on the preliminary part.
So one thing that is clear, because this, from other side, there's the firing also was here. It is reflected in report itself.
Acha.
So report itself reflected by the district judge, not by the, as per High Court order. And this is a criminal petition is pending before the High Court.
You could do one thing, you come next week. I'm here, we will decide on this prosecution sanction.
Fine, we are anxiety is met tomorrow.
Nothing will happen, it's only a BWA. Let them come, they will be,
Because they are now sending the available warrants to the person, those who are not solicited by the police.
those we are not concerned of. We are concerned with the
That is
petitioners.
the conduct.
Ah.
I'm saying only conduct.
Mm.
Now, the on the conduct is that these people, those who are and they solicited, they are not involved. To them also, the court will.
BWA, they can also come, get a
I
bail.
understand, but
Huh.
what manner of court is going on? This I'm saying.
See,
This search
court is also not very unreasonable. They had issued summons, second time also summons, then bailable.
This person to whom I saw my friend, for whom this available warrant was issued, they have not been solicited. They have not been solicited in the case. Just from.
Those records are not before me, I cannot.
Charge sheet is there before.
Huh.
not before.
Charge sheet is of course against these five,
Yes.
against this five, right?
No,
Charge sheet,
other also, there it is there.
see, okay.
Yeah, you're not just for my satisfaction, even may perils.
Okay,
Page 39 of survey.
39, okay.
This is number 12.
Yes.
Particular accused person not solicited, suspect.
Gagandeep and all. There are so many.
Yes, page 43, serial number 10. Sipoy Mansingh. Sipoy Mansingh. Sipoy Mansingh. This order.
Sipoy Mansingh is not charge sheeted, right?
But even in this.
But my lord, he is not a petitioner here, my lord.
It's for his satisfaction.
Not that, but the manner this, the court is going on.
That is different case.
Because there's one year search, it says there is no sanction is pending. The court should not take cognizance.
But you can only press the issue grievances which is before only your case. You cannot.
Yes, I understand, but when
It is not before you.
my affidavit is not as, then there is some judgment should be placed for this honorable court.
So let matter be fixed on. We can take it some.
So, see,
I
Miss-
understand, but my lord, when the question is, there's not any objection is raised, that should be with the supporting the judgment. Here, my friend only delaying this another day. This morning also, they are not getting copied, and therefore nowadays, this affidavit is not there.
things are not,
I
we
understand,
also do, I was also on the other side when these things occur at times.
The unnecessary people are dragging, this without the.
No, but if had his actions been good, if he would have appeared on the first day or without any steps, that was not
I
being conduct.
understand, but
Then, okay.
law protected the public servant. Even Supreme Court been various as many your lordship is aware of. This in Army General Commanding Officer judgment in every in our High Court also. This I am placing one judgment before his honorable court where I appeared. Where his honorable Guwahati High Court from state problem.
No, and understand they are in the service of the country and then they should be protected. But it is their duty also. When they have received the summons, then they should have at least, see, summons were issued in June 24. And then the next date was August, June, July, August 24. And there is no averment that they did not receive the summons. So after having received the summons, they should have at least respected the court and come before. But M. Kato has entered appearance only for Pradeep Dabas in respect of other four. Where are they? Jaspal, Gurmeet, Gurdeep, are they still in Jammu Kashmir? Where are they?
Yes, some of the now, maybe I have no proper information. They are in border.
Tomorrow is the date fixed.
Yes, and that is tomorrow protection is the only place I'm not, if Lordship may fix another date, I have no problem.
No, but then
I understand, the next that my petition.
had it be NBW, okay, I would have understood. This is BWA. There is no requirement of interference by this court.
People will come from the proceedings from the border.
They know this date from before. They should come
I know, this.
on the day before this application is
This
moved.
one is also pending from before it is not to take it to another. So, any that yesterday, tomorrow, that may be only protection may be given. Is it there? In this first week of July. Third July.
But that prayer is again not there in your petition. Right. Only for quashing of this and then.
Yes, man, stay of the proceedings, yes, my prayer is there, but this honorable court has every power to this do. Because I appreciated the proceeding of the interim.
The next date of appearance is when? Tomorrow, right?
So yeah, that protection may be given. Then the next you'll also may fix on third of July.
For them to appear before the court.
3rd of July, this matter had my run this so far.
Yes, madam, that can be done, madam.
And madam, on 3rd of July, this.
Let them appear before on the third of this month, 3rd of July.
Not-
And same day, matter can be.
They will appear, if required, they will appear on 4th of July. This case may be.
No, what I want is they should at least appear before the court.
Sir,
Their conduct I don't find good.
My lord,
They are in the service of our country, but they should follow the court's order. Then,
This would be also low.
When procedure followed by the court below is wrong, we challenge that.
you challenge that you have challenged after years.
Yes, ma'am.
Then, only after this.
Even when we appear before the honorable court, we are explaining the reason.
No, they don't have respect for the court.
This army.
Because otherwise they would have filed the application challenging the cognizance order before. I will not pass any orders. Let them appear tomorrow and I will hear.
Tomorrow is not possible, there's my full solution, not that may be. On court, this, nothing will happen. Now, today is this 25th. Court may be fixed for again, and third and this may be. This must.
Had their conduct been good, I would have. But
Yes.
then,
My lord, on court, they will appear.
no, before, even if I change the date, it will be before the hearing of this petition. Tomorrow, okay, from border, there might be some climate, weather problem and all that, they may not be able to come, but day after tomorrow or some other date, they have to come and appear. And after that, I will hear this.
Same date, my lord, court might be-
No, not same date. They'll have to appear. This is not done. On the first day, they were without step. Second day, somebody came, appeared for one.
My lord, for my suggestion, I'm sorry. Same similar to the also case, my lord. Here is from all officers, my lord. Minimum 11 officers was there, my including. Yeah, there is PI filed against them. According to illegal it was taken from there. And there the direction was given to CBI. CBI starts with CBI starts that proceeding sanction was not taken. And we filed petition report order of this learned court, my lord. So here only, my lord.
Oh, see, everything depends on facts.
So that.
And you will not find two cases with similar facts.
That is, my lord, there is one back and from that people,
Ah.
the court quite
Hmm.
right, my lord. Here, judicial inquiry, that here judicial inquiry is also against us, my lord.
Hmm.
Here judicial inquiry is against the army person, my lord.
Hmm.
So my small prayer, madam, this it is nothing you said, madam. Okay, court, the decision about court, fix both of the appearance as well as this case.
No, that I will not. I'll pass the order.
So then when till court, my lord,
No, they let them appear. Today is what? Today is 25th. 25th of June. So let them appear on 30th of June, Monday. Let them come. And then we will fix this case on July. In July.
July 3.
Okay. Heard Mr.
my lord,
S.K. Mehdi.
38, my lord, instead of 38, any other date, second July, my lord.
Why 2nd July? So many days I'm giving for them to come. Otherwise, I'll fix it tomorrow.
Yes.
Okay. Heard Mr. S.K. Mehdi.
My lord, they actually absent one adjudication.
No, they have to appear before the trial court
Yes.
on that day. You know, the case will not be listed. Only that they are unable to come from the border areas. So let them come. On 30th, they appear before the trial court and the case will be listed for hearing on some other date. On
Then-
cognizance.
Yes, on third of July.
3rd of July will be too late. 30th.
Okay.
I'm giving enough time.
Man, they will appear,
Ha. And the case will be listed on 3rd of July. Okay. 3rd of July.
Yes.
Okay, this is a Thursday.
Yes.
Yes.
Or second of July, also go.
3rd of July. Okay. Friday, I'll be going little early, so. Okay, heard Mr. S.K. Mehdi for the petitioners. And Mr.
El Kurdu,
L. Kudu.
SPP, SIT.
Okay. The special public prosecutor for the special investigating team.
Yes.
You were constituted to look into this case, right?
Yes.
Constituted as per order, so was order what?
Yes.
By which order you were appointed?
It was
Some executive order?
executive order, I think, my lord. Investigation. was-
Appointed, it's okay. SIT appointed to investigate into the offense in question in the instant. What is this number? Case number? 3. Instant criminal petition, in the instant criminal petition. This petition, not Mr. This petition is filed for quashing of the order dated, the quashing of the FIR dated 17/5/2020. Lodged in connection with what case number?
My lord.
Case number, case number,
The search sheet number is 54 23
the charge.
Fire number 27, 24.
27.
What is this police station case number? This is in connection with
Well,
Longing
Longding
Longding.
police station case number
27, 20.
27 of 2020. 2020.
Yes.
2020. As well as the charge sheet submitted,
GR case number, charge sheet
as well as the charge sheet submitted
54, 20.
in connection with the said case on 4/12/2023. As well as the order dated so and so, wait, order dated, where is the cognizance?
Five, six.
Order dated 5/6/2024, by which the Court of Judicial Magistrate First Class Capital Complex at UPR took cognizance of the offence upon perusal of records and on finding of a prima facie case against the accused persons. The petitioner has challenged the FIR as well as the subsequent proceedings. Oh, no, has challenged the said order dated 5/6/2024 only on the ground that before taking cognizance, no prosecution sanction was obtained. The petitioner has also challenged the order dated 23/2025 passed by the said court, by which bailable warrant of arrest were issued against the petitioners for their non-appearance on 13/8/2024 as well as on 27/11/2024. Full stop. It is seen that the court had wide order dated the court, while taking cognizance of the offense, wide order dated 5/6/2024, issued summons to the petitioners for appearance on the next date. However, on the next date, only one petitioner appeared through the counsel, that is petitioner number 1, but the other petitioners were absent without steps. And as such, the learned court issued fresh summons to the petitioners. Thereafter, on the next date, it is seen that thereafter, on the next date, that is on 27/11/24, it is noticed that the petitioners did not present themselves before the court. However, they filed a dispense application full stop. The learned court, however, rejected the dispense application because the same was not supported with any official documents. And as such, the learned court issued fresh summons upon them. Thereafter, on the next date also, the petitioners did not appear before the learned court, and the learned court returned a finding that the excuse provided by the petitioners for their absence was not proper. Full stop. A dispense application was also filed and the same was rejected. Since the petitioners did not appear before the court in spite of the summons, the court was constrained to issue bailable warrant of arrest against the accused person. Mr. Medhi, appearing for the petitioners, has made a prayer before this court that the petitioners are posted in far-flung areas, mostly in the borders. And they are they are unable to appear before the court on 26/6/2025, that is tomorrow. Mr.
L Kurdu,
Yes, huh?
L Kurdu.
L2B, yes. Acha. The special public prosecutor for the SIT submits, SIT takes up the preliminary ground of challenge. That is, the affidavit filed along with the instant petition was not a proper, is not a proper affidavit, as the same was sworn by, not by the petitioners, but by one Jagram Singh, who is working as a deputy commandant, 24 Assam Rifle. Full stop. He stated that Mr. Jagram Singh, no, he stated, nahi cut that. Full stop ke pehle padho tha. Just read the last line. He has taken up a preliminary ground. Is not a proper. And who states that the post, the place where he is posted, the petitioners were posted at the time of the incident. Full stop. He as such stated that the affidavit is improper and the present instant application is not maintainable on that ground. Mr. Special Public Prosecutor, therefore, seek some time to look into the same and has prayed for some time and has prayed for adjournment in the matter. Mr. Medhi vehemently objects to the same and has prayed for taking up the case. This court, upon seeing the orders of the learned trial court, upon seeing the orders passed by the Court of Judicial Magistrate, JMFC, Capital Complex, has reached a finding that the petitioners did not appear before the court below without any proper reasons. It is also seen that the instant petition is filed on which date you have filed?
18.
Date is not there in the affidavit also. Why no date? Oh, it's there. 17th of June. 17th of June. Yes.
17th June,
Huh.
and
This instant petition is filed on 17th of June 2025, challenging the FIR, the charge sheet, as well as the order taking cognizance. which was passed on 5/6/2024. Which is after almost 1 year. More than 1 year, right?
Yes.
No, no, no. This is June and June only. Yes, more than 1 year. After more than 1 year. It is crystal clear that this petition is filed only after the BWA, the bailable warrant of arrest, has been issued against the petitioners. Where? Since Mr. Bhemedi has expressed the difficulty of the petitioners to appear on 26 6/2025, this court, taking a lenient view, directs that the petitioners should appear before the Judicial Magistrate First Class UPR, District Papampare, on 30th of June 2025, instead of 26/6/2025.
In case number Saturday.
No, 30th is June is Monday. 30th June, huh? So and so before the Iman. By modifying, for appearance so and so, by modifying the order dated 23/2025 passed by the Judicial Magistrate First Class UPR. As far as the present criminal petition is concerned, this court allows Mr. Special Public Prosecutor to look into the various aspects of law, including the maintainability of the instant criminal petition, as well as on the requirement of prosecution sanction before taking cognizance in the case. List the matter after. Oh, when do you want?
Third July.
On?
3rd July.
List the matter on 3rd July 2025. Okay, little bit here and there.
Less.
Nothing is against you, but then I didn't find the conduct of that person good. Nothing is, I didn't find the rest. Okay.
I have this.
Additional affidavit is filed. Some-
Yes, my lord, the item number 11 and 12 are connected matter
Ah.
arising out of,
Connected.
yes, arising out of same FIR, ma'am, and
Okay.
two accused,
Two accused.
yes, arrested in connection with the NDPS case, ma'am.
Achha. You are ready?
Yes, madam.
You'll do it?
My only this certificate copy, my lord, today I'll get on.
He may be allowed give him a copy.
Yes, madam, copy.
A
Yes, madam.
copy of this order may be furnished to Mr. S.K. Medhi during the course of the day.
Right.
Okay. During the course of the day, will it be possible? That's okay.
I'll after 4
4 p.m.
4:30.
Acha. Right. Come at around 4:45.
Yes.
Lordship, currently I'm in judicial custody.
Hmm.
I was arrested under section 120,
Wait,
21 B of the NDPS Act,
B, not commercial,
not intermediate.
intermediate. You were arrested on 7/5, not
7/5.
very long,
Yes, 45 days so far.
45 days,
49, sorry.
49.
49 days.
So another 11 days to go for your default bail.
Yes. So, Your Lordship, so far, Your Lordship, I have given my statement before the investigation officer. And Your Lordship, the investigation is substantially completed.
Hmm.
Your Lordship, there is no need for further detention of the accused person. Your Lordship, the very purpose of,
That police will decide.
yes,
They have not filed their charge sheet.
but so far I have given my statement. Your
Huh,
Lordship.
you have given your statement. But
So
they have
you-
not completed their investigation as yet, and then, okay, let me see the merit of the case.
Your Lordship,
What is-
here, Your Lordship, in Your Lordship, the accused person has a wife and ailing mother.
Acha, this is Srimati Rehna Begum.
Rahina Begum.
She is the wife of Rajibul Islam.
Sorry, sorry.
Saik Farid.
Sorry.
Oh, his husband is not an accused.
Husband is the accused, my lord. On behalf of the husband, your
Oh,
lord.
acha, acha.
She's wife.
Okay. Hmm.
Because it currently Your Lordship, his mother is undergoing a medical treatment.
I feel hot. Let, switch on the fan. Or there is one another fan, no. Acha, wait. Let me see the accused name. Sheikh Farid.
Sorry.
At the outset, my lord, I would like to apprise your lordship. My lord, I have the case diary. In actually, case diary in item number 1 has been returned back because on that particular date when the matter was fixed,
Hmm.
they have taken time. But in item number 12, case diary is there, but your lordship, the statement is not there. But the from the status report is there where their involvement has been reflected, my lord. If that
Achha.
is sufficient, then your lordship take it. Matter may proceed.
In the case there is not there.
Case diary, your lordship, actually the both are connected matter, my lord.
Okay.
So case diary is there, their involvement has been reflected, but statement is not there in the case diary. That is only there.
The statement of the accused.
Yes, your lordship.
Not required. You
Okay.
can take it up. Okay. So what is the FIR? Page 16.
So may I read?
Okay.
In regard, I am submitting a below mentioned line for your kind consideration. Please on 7/5/2025 is around 19:13 hours. The global information was received from a reliable source that a drug peddler is in possession of suspected contraband drug heroin and is selling it to the addicted few of capital Aishari, Premnagar, Naharlagan. The source further stated it is not apprehended earlier, they might flee after discovery of the contraband substance and shift its location. The said message was conveyed to write kilometer into general diary by GP Congress so. And after this, SPICR and SDP and all level world were conveyed about the same and they give verbal approval to conduct the raid. Further, Skin Allaga Aisha was also implemented by even messages as well. There is every possibility that the player might seek the location and temper the evidence. So I have decided to proceed to the.
There is every possibility. You missed one line. There is every possibility. My shift to his location. Temper the evidence. So I have decided.
So I have decided to proceed to the court immediately without obtaining third warrant from concerned registered. Accordingly, team led by the under present with Mr. Vivek Lingvi for Head Constable P. Kari, Constable B. Gora, Constable K.
This is without obtaining search warrant is wrong. Here, without obtaining authority letter, it should have been this way. Okay, then, because it is on reliable information, no? He entered the things into his general diary, which is required under 42. And thereafter he went ahead. What he requires is an authority letter from a superior officer. Okay, then?
Team led by the under present Arabic Premnagar Nahalagar, the team apprehended 1-3 Saiful Islam. Samuel Soluso, he was served notice under section 58 NDPS and his personal search was conducted, but nothing was found. Upon search of his room, 37.
Was it at night or daytime?
It was during morning. It was morning hour.
No, no, at around 13 hours,
15 hours.
information was received. Then
19.
it was in the daytime or night? Huh, Mr. Ete? 1913 will be what? Afternoon? No,
Night.
night.
Night, your lordship. 1913 will be night, but its source 790. That is the, your lordship, at that point of time, the information they have received, your lordship.
Huh. So when was the search made and all?
Twenty.
7 o'clock. Information received at 7 p.m. 7:05,
Yes.
which is evening. It will be
Yes.
dark, May
Yes.
time, May
Yes.
month.
Yes, ma'am.
Okay. Okay, then let's go ahead. The team led by undersigned arrived at so and so. The team apprehended one Sariful Hussain. He is also an accused.
He's poetry.
Acha.
Not before this court.
Huh?
Not before this court.
Not before this.
Serve notice under section 50 NDPS. When his personal search was conducted, but nothing was recovered. Upon search of 27 vials containing suspected heroin, weighing 48.7 grams, including weight of vial, and 6 antiviral kept in a black color polythene was recovered. Upon examination, he disclosed that more people are coming to Temple Nala.
For sale,
Selling drugs. The same was implemented to Garnet, SP, IC, and Nahalagan. The police team then left for Temple Nala along with apprehended question. Three, Tariful Islam. The team intercepted 2 drug peddler in Temple Nala, but both attempt to flee from the school on motorcycle power. Judge Domina, hearing number 12. The team apprehended them. They have been identified as the 3 site for it.
He is the petitioner.
Yes, it's
Shaikh Farid.
site for it.
Ah.
And we will be, then, Ashraful Islam.
Wait, Ahmednagar, Gaon number, so in Lokhimpur, and Sri Ashraful Islam.
They were served notice under section 50 of NDPS. And upon search, 2 plastic pouches containing suspected heroin weighing
Body search.
body surgery,
Acha.
each weighing 13.3 grams, marked as exhibitor A, and 11 grams, marked as big B, weight of plastic pouch containing in 2 separate brown colored soap. Yes, were recovered from possession of 3 types for in his pocket. They came from Lakhimpur. 4 of them were came from Lakhimpur to sell such contraband substance to illicit heroin of addicted fuel of Nahalagar and Itanagar. The total gram 73.4 grams of suspected contraband drugs heroin, including the weight of plastic pouch and barrel and motorcycle seized from the possession.
So this is intermediate quantity.
Intermediate content.
Heroin is, what is commercial?
Commercial
20 grams.
20 grams. You know, see, from my position only 13.3 grams.
17.3.4 including the weight of the.
All the contraband substance and motorcycle used as a mean of convey for drug trafficking were seized, sealed and faked and put by MR number 44 of it, 45 of it respectively. The police team, along with all apprehended persons and seized contraband, began to Nahalagar. PAC Nahalagan, Kodabad arrived at Nahalagan, and all the recovery contraband substance produced before him. The same has been introduced to learned SP ICM Nahalagan. Given the above fact and circumstance, it is learned that the said question, namely Muhammad Sariful Islam, Muhammad Said Farid, Arif Islam, Ashraf Tabler, who usually come to Nahalagan to be selling such drugs to the addicted Europe, Asia, destroying their futures. Therefore,
Okay.
you are therefore requested to initiate necessary legal action.
Okay.
Because it is an FIR.
Hmm.
But you know, see, if we come to the Caesar memo,
Page 20.
Caesar memo, page 20.
This is from Shaikh Farid petitioner.
Caesar was done at 200 hour. Page
Uh-huh.
200 hour,
20.
20 hour,
So 6 o'clock. No, 8 o'clock.
8 o'clock.
8 o'clock
PM.
at night. Okay.
And you know, see, arrest was made 8 hours.
Yes.
Arrest memo. So you know, see, there is a 12 hours gap between from the arrest and from Caesar. You know, see, he was, you know, see, as per the
No,
record,
he was arrested and then he was arrested at what time you said?
arrested at 8 hours.
Huh?
8 a.m.
8 p.m.
8 a.m.
AM?
Yeah.
How come AM? Show me. Because he received information 7 o'clock.
Yes,
7 o'clock on 7/5.
7.
And then he went and he caught them and seized the articles. So, and this 8 p.m. Caesar was made. Right.
Yes, no, you know, see, he was first arrested. Information was received,
Arrested at?
arrested in 8 hours.
Where is the arrest memo?
22.
22. Acha,
The morning of-
22.
The date is same only, man.
It is same, but the timing is.
Perhaps some discrepancy because.
But 7/5, how can it be 8 in the
Yes, Your
morning?
Lordship, some discrepancy is there, Your Lordship, because how that person will be arrested in the morning and,
Oh,
yes, definitely there is some typographical error. there.
there's some mistake.
Yes, Your Lordship. And that is same only, man.
The date is same.
Yes,
It is
It
same.
is not 6/5.
yes.
It has to be after 7 o'clock in the evening.
Yes, you know, see, but.
After
if
receiving
they
information.
Enter 8 hours.
That
There's some typographical mistake.
typographical aspect.
But then the advantage will go to you. But let's see.
In the case, you know, see, basing on the record documents, it shows that the accused was first arrested. Thereafter, you know, see, the search was made from his body. Recovery.
No, his arrest will definitely after 7 o'clock. Seeing the FIR. But FIR is clear, no? When they were trying to flee.
You know, see, timing has not been.
Not there, but then he said the information was 7:13 hours. So then when he tried to flee, he was arrested, he was apprehended, Shaikh Farid. From him, this articles were recovered. And Caesar list also shows that it was seized at 200 hours. So it is 8 o'clock, right? 200 hours, it is 8 o'clock.
8 a.m.
8 p.m. 200 hours, how can it be AM? 8 p.m.
200, but 8 hours is a.m. It is a morning hour.
Arrest memo shows something different, 8 hours. That is a mistake. That has to be.
Caesar memo is also suffered from discrepancy.
Why?
Because you know, see, they had bear the name of Kodabad APS, who has witnessed the seizing process. But you know, see, there is no signature. And you know, see, if you peruse carefully, page number 20. If you peruse the Caesar memo, the content, it is apparently, you know, see, understandable that this whole content of the Caesar memo has been written by a single author whose handwriting is same. Even, you know, see, they have tried to give in the signature of the two other accused person.
No witnesses. What?
Accused person.
No,
In the
seized
Caesar
from the
memo.
possession of Shaikh Farid, son of so and so.
This is executive magistrate, man.
Accused, but you know, see, there does not bear any signature, and the handwriting is similar. It is visible that it has been written by a single person.
This page 20. Where is the bar? Where is the bar? This is written by the officer in charge of the police station Nahalagun.
Yes, you know, see, but you know, see, Kodabad, you know, see, APS,
I mean, witnesses' signatures, why is it, the handwriting can be same, the same person have written. The signed signatures
signature. It's a
of Sariful and Ashraful.
No, you Kodabad signature. Witness number one, Kodabad APCS.
Kodabad. No, this of course, the name is written by the person, but the signatures, you cannot say is by the same person.
No, your lordship, signature is not there.
It's a matter of trial, my lord.
It's again, he is right.
Your
This
lordship,
will be
yes,
seen.
Your lordship, it may be a matter, it is a matter of time,
Hmm.
but your lordship, even before the matter is taken up, if discrepancy is available, the benefit, your lordship,
This is not a major discrepancy. Why? This Kodabat and Panyo, these names are written by the same police officer, but the signatures are of them. So see the signatures at the right. You cannot say that these signatures are by the police
Your
officer.
lordship, signature in what I have received, it's a document, no signature is there.
Why? There are signatures. On the right side, small.
Small, there is a signature of other two witnesses. Head constable, Ponyo Tani, and constable, Devojit Barwa. Three witnesses are there who has witnessed the seizure process.
But these cannot be grounds for bail.
Yes, your lordship, this cannot be ground for bail. But
So
your
look,
lordship,
show me the merits. Okay. Okay, you are right in saying arrest memo is something to be doubtful. Then,
your lordship,
what else?
the accused person, your lordship, is the only breadwinner of the family, your lordship. Because of his arrest, detention, your lordship, whole family member is
Hmm.
facing financial difficulties. And your lordship, I have enclosed the medical certificate of the accused
Hmm.
mother. She is since 57 years old.
Hmm.
Annexure B, Annexure 5.
Okay, those are your different grounds. The mother is not well.
Yes, your lordship, currently, your lordship, she is facing a breathing problem. Your lordship, I have filed an additional affidavit.
Hmm. Yes, it's there on records.
Additional,
Additional affidavit is for what purpose?
medical, your lordship.
Of the
Recently, there
mother.
has been, yes,
Of the mother.
mother. Recently, she has undergone a endoscopy.
Gastro problem.
Your lordship, he is suffering from hiatus hernia heel grade 2. Your lordship, yes. So,
Where is that? Which page you are
page
reading?
number 31.
31, yes. 31 only I'm here. This is gastro so-and-so report. Mucosa, fundus, centrum, no food residue. No.
And page number 22 of the main petition. It has been certified by the doctor that the mother has been undergoing a treatment since last 6 months under his care.
He has no brother, sister.
No. The mother is staying with the accused person. Then your lordship, even accused has a minor child who is 3 years old now.
So what do you say, Mr. Ete?
My lord, so far as the discrepancy is concerned, your lordship,
Hmm.
that are the matter of trial, your lordship. Here, your lordship, the prima facie case, whether there is a case against the accused or not.
Hmm.
So far as the seizure is concerned, my lord, the intermediate quantity has been recovered. No doubt it's not a commercial quantity. Rigor of 37 will not come.
Hmm.
And the investigation period is 60 days.
Hmm.
So, my lord, here in the status report, the IO has clearly stated that they are not only, there is a networking.
Hmm.
They, among both this accused person, one was the Pelion writer, your lordship. From his possession, the contraventions were recovered. But the other cannot ask for the benefit that I was not in the position. It's a conscious position is there. Presumption will definitely be there. And the second part is, your lordship, it is not for the first time they came here in the Itanagar and selling this contraband substance. They are procuring it from the outside the state, from Assam itself, your lordship. So to your lordship,
Kind of habitual.
yes, your lordship.
There are records, there are something to show.
Your lordship, actually their statement itself clearly reflect that this is not for the first time they have done it. And your lordship, that is why I was indicating the 180 statement, your lordship, there because
He has himself said.
yes, your lordship. So this aspect has to be taken into consideration. This is not a, your lordship, the general offense, because the NDPS, your lordship, is a menace to the society, your lordship. If they are easily released to be enlarged on bail like the general offense, your lordship,
They'll keep doing.
it will keep doing, your lordship.
This NDPS cases, one should not be granted.
Yes,
bail.
exactly, your lordship.
You have spoiled the entire society.
And your lordship, now,
All homes, few.
and your lordship, now your
families.
lordship will find the possession they are keeping. They are
Hmm.
very clever now, my lord. Their modus operandi is they are keeping intermediate quantity. They are
Hmm.
now, if commercial quantity they have taken, they will keep under the bar for 180 days or 365 days, and rigor will come. So now it's your lordship. It's in our state itself, your lordship. It's your lordship. In every street, everyone. You recently also in every news, your lordship, the drugs peddling. I'm not in connection with this case, but we have to concern about the society also, man, because it has a direct impact on the society.
Acha, what is the total amount that was seized?
Total 73.4 grams. It's an intermediate.
That is also intermediate.
Yes, my lord. Small quantity is 5
grams.
5 grams, and the commercial quantity is 250 grams, my lord. It's in column.
Heroin.
Yes, sir.
Heroin, right?
Yes, heroin, my lord.
Just show. Let's see.
Your lordship, in column 56.
Why I am under the wrong impression? 20 grams. What is
5 is
250 grams?
yes, that is the commercial quantity.
Hmm.
So now it is in between, intermediate. Yes.
Even if we take the entire amount, it will be intermediate.
Intermediate.
Right? And what is the law? I haven't seen it for some time. Whether the entire thing will be considered, or whatever is taken from individually taken from
So,
the.
my lord, if entire has to be taken up. Ambala case, your lordship, here recently the Supreme Court has passed an authority on 52A. There every aspect has been decided. Even if suppose the contraband substance is with some other material also, it's not need to be separate. It has to be taken as a whole. So now if two persons are coming together, and if suppose they are, if investigation agency or the prosecution establish that they are from the same gang, or they came from the same locality, same place or procured from the same person, and if they divide it within themselves and coming from the different way. So if they all are apprehended on the particular day, it cannot be, your lordship, cannot be say that this if there is a nexus, if the prosecution could establish,
the
entire has to be taken into consideration, because from
that is there in Supreme Court judgment.
your lordship, there, your lordship, in Ambala matter, I think, your lordship, that aspect is there when the contraband substance is
No, mixing with other foreign materials, I'm not talking about
okay.
that. If the entire quantity is more than intermediate, and
But the
then
person,
if we take it individually, then it becomes
your lordship,
lesser quantity.
that aspect is your lordship not dealt with, your lordship. If suppose if the possession, if some intermediate quantity is been recovered from me and some small quantity is recovered from him, that the both has to be booked under the respective aspect.
Acha.
That is there, your lordship. It cannot be.
Anyway, in this case, so even the entire quantity will not come within the.
No, Your Lordship, it will
But
not
then,
be differently, Your
but then the fact is that you have tried to flee, and then they apprehended you with that amount.
No, Your Lordship, I have never tried. It is there in the record, it is reflected as it is, but Your Lordship, actually, I have never tried. Your Lordship, I have not gone to the merit of the case. Your Lordship, here, Your Lordship, the accused, Your Lordship, just consider the medical condition of the
Mother.
accused mother, Your Lordship. She has been, Your Lordship, the family has no any source of income. So all are dependent on the accused person. Your Lordship, if the accused person is not released, Your Lordship, the mother will deprive of his medical care. Your Lordship, if medical, Your Lordship, if she,
No, it doesn't seem that she is very serious.
Your Lordship, breathing problem, and since last many years, Your Lordship, she has been undergoing a medical treatment.
There is no evidence of edema, erosion, ulcer, so and so, no evidence of modality, normal. Hiatus hernia heals grade 2. What is this, Mr. Ete? Hiatus hernia heals grade 2.
Even my lord, I am not expert in medical science, your lordship.
Just check it in the Google if you can. And where is the pleading that you are the only son?
Your Lordship, I have not contact. Your Lordship, right now the mother is staying with me.
But you are not the only son. There are other brothers and sisters, it seems.
So, Your Lordship, I am not aware of this. As of
You are
now-
not aware of your brother sister.
No, Your Lordship. Right now, Your Lordship, wife and son and mother is staying with me.
Wait for another 9 days. If they do not come up with the charge sheet, you will get default bail.
But you know, condition of our mother is very. So since last 2 months, you know, that she has not been.
You have moved bail application earlier also.
One bail application was filed before a special judge, it was rejected. You know,
I mean, before this one.
Rejection order is page number 15.
Your Lordship, the disease, it says it involved the stomach fundus upper part rolling up alongside the esophagus while the gastroesophageal junction where the esophagus meet the stomach remain, it's a normal position below the diaphragm. I don't think it's a life-threatening disease.
This is gastro.
Yes, yes.
If it is not treated immediately, then Your Lordship, in future, it might develop a major problem.
Now show me that rejection order. Page number
Rejection order,
14.
Page number 14.
But in the order, it is said that 50 notice is not given, but it is given. That was a submission.
Yes, yes, Your Lordship, whatever we have obtained through CTC, we have not received any such such document that showing that notice under 50 has been served to the accused person.
It's a part in the FIR.
On merits, you have a weak case. Even 50, section 50 is not violated. It is done in presence of the
May
magistrate.
said yes.
Right. So on merits, but only on this medical ground where your mother is not that very serious and she has other children's. So I don't think so. This is a case for bail.
Because it comes to page number, Your Lordship,
22.
First claimant.
Huh. What that discrepancy?
Discrepancy, Your Lordship, not only discrepancy, the ground of arrest has not been provided, Your Lordship. As per the judgment, Your Lordship, as per the direction of the Supreme Court, the ground of arrest has to be, at the time of making arrest, it has to be communicated to the accused person. But in the case, Your Lordship, same has not been observed. Your Lordship, my humble submission is that, Your Lordship, even Your Lordship, if the mandate constitutional provision is not complied with at the time of arrest, it will not vitiate the trial, Your Lordship. It will only vitiate the bail, Your Lordship. So, arrest.
The ground of arrest, my lord.
Ground of arrest was given.
Yes, it's in both
No, Your
cases.
Area ground, you have been assigned your reasons. You have been arrested for peddling of contraband substance which constitute an offense under punishable. This was given to you. Ashraful, Shariful. What about he?
Saripul, in next matter, my lord. Asrapul.
He is something else, no?
Yes,
Shaib?
this is side for it. I've given the, your lordship, he's also.
No, this is given to Sariful and Ashraful. What about the present petition?
Your lordship, your lordship, that's why for this present accused, your lordship, CD has been sent back actually. For him,
Oh.
CD has not been received. The CD we have received for item number 12, your lordship.
This has to be seen from the CD. Because ground of arrest is an important point.
Yes, sir.
Now, ground of arrest were given to other two accused persons.
And why not?
But in your case, it is there in the CD.
Your Lordship, but Your Lordship, I have not been provided, because if it is kept secretly, then there is no meaning of communicating the ground of arrest, because your lordship, the reason, the very purpose of communicating the ground of arrest is to afford me an opportunity to defend.
No, that we will see from the case diary whether it is communicated to you or not.
Yes, but because as per the arrest memo, your lordship, it is.
No, arrest memo is different.
It can be punished separately together with the arrest memo. It is not mandatory that it should be punished with the arrest memo, but prior to the remand order, my lord.
As soon as possible.
Yes, as soon as possible, let us by prior to remand order, but not after your lordship order of remand.
So let the CD come. I'll have to see your grounds of arrest. Okay. When can you? To bring it next week, Monday?
Okay, madam.
Okay. Then, heard.
For other accused, your lordship, CD is there, the next item.
Acha, acha. As far as this one concerned, right, for Rehana Begum, item number 11,
Yes.
heard Mr. So-and-so and T. Additional public prosecutor. It is seen from the,
Last order.
from the last order dated 17/6/2025 that the case diary was returned back to the police station. During the course of the argument, it was, during the course of the argument, it became necessary, the necessity was felt that the case diary has to be produced.
Yes.
Call for the case diary, fix the matter on Monday.
The next item can be maybe considered, my lord, the item number 12. For
Same, Rajibu.
For Rajibul, your lordship, although statement is not there, but your lordship in status, I have made the submission, the intimating material is there. And now the last ground was the ground of arrest that is also there in connection in relation to this, your lordship. Rajibul is the, my lord, the applicant, and main accused is the Asraful Islam. For Asraful Islam, ground of arrest is already been furnished.
Asraful Islam I have seen, but what about Rajibur is appealing for whom?
Rajipul is, my lord, Rajipul is the applicant, it's a regular bail, my lord.
Okay.
For Asriful.
Mal Rajibul is my case in item number 12.
Give me again.
Rajipul Islam is the applicant for Asraful Islam.
Acha, he is relative to
Yes,
Ashraf.
yes, yes, sir.
Cousin brother.
Ashraful's ground of arrest just
Yes.
give me.
Apple is mal.
And they have not taken that plea also, my lord.
Now, my lord, since I have got the information that the CD is available in the item number 12. Otherwise, my lord, generally I used to confirm, because without confirm the CD, arriving of the CD, this hearing is the futile exercise that we have just covered up.
No.
Yes, now, my lord, this item number 12 is the same out of the same PS case and the same allegation, but I have the different putting, my lord, that I'm Asraful Islam in the accused number 3.
Acha.
Now, my lord, in the previous item, this already FIR has been read out. Therefore,
You need not.
I need not to bother this honorable court to repeat again and again. But my lord, may kindly come to my petition in the page number 19, my lord. This is the annexure 8, the time
He is 8
column
hours.
20, yes, that I'm not on the merit of this case. But in the, my lord, arrest signature of the arrestee, there was no witness. Despite that, my lord noted in the state of the Bengal versus D.K. Basu, my lord, that one witness is necessary. What, my lord, I'm trying to appreciate that the one witness, signature of the witness was necessary while I was arrested. But my lord, since this is the bail court, I am not on the merit. This is subject to the, my lord, trial. Now, here, my lord, I have limited whether I should be in the bail or jail, my lord, in the single issues. My lord, may kindly come to the page number 27, my lord.
Acha, Mr. Ete,
Yes, my lord.
just see page number 20. It is 8:05 at 8 hours. This 7:05 was mistakenly written.
Your lordship, that has to be confirmed because your lordship in ground of arrest also, your lordship, it's written 7/5/2025, my lord.
Acha. 7:05.
Yes, my lord.
No, where is date of arrest? So here 7:05.
Yes, my
But
lord.
then here in the accused challan,
Yes, your lordship.
it's written 8:05. This
Affecting-
can be actually the fact at 8 hours in the morning.
um,
But how come? They were apprehended immediately after the,
Yes, after seizure only, your lordship, they have been arrested, your lordship.
that can be clarified from the general diary entries.
Your lordship, general diary, in fact, my lord, I've been looking for the general, they have not annexed the general diary also. That is the difficulty. General diary, otherwise from general diary, it can be easily ascertained when they have
Yes.
closed the CD and when they have arrested and when
But
they have.
it's not available.
It's not available here, my lord. It's just,
See, GD entry should be.
yes, your lordship.
Yes, my lord.
Actually, most of the time, your lordship, they usually send, I don't know what wrong with the IO, they have not sent the proper, your lordship, GD entries. From the GD entry, your lordship, it can be
In
ascertained.
fact, Ms. Mahaki, you write that call for the city along with the general diary entries.
Yes,
General diary
GD entry,
entries.
general diary entry.
Because in Guwahati High Court, they always send the GD
In
entries
most of the cases, my lord, they usually send, I don't know why they have not sent in this case. your lordship.
along with the general diary entries. Okay.
From there, it can be easily ascertained
Mm.
because their exact date will be there.
Okay, Mr. I interrupted in between. Okay, then.
Now, my lord, on page number 27. In corroboration with the FIR, my lord, this page number 27 is the seizure memo.
Hmm.
From the seizure memo, my lord, it is clearly that the first one is the first accused person,
This is Shaikh Farid.
Sheikh Farid.
Where is
And-
your Ashraf?
And the second one is my lord. That is why, my lord, I am trying to display that it is very clear that nothing has been recovered from me,
Okay, next please, Sariful.
my lord.
Ashraful, there is no seizure.
In case of the Asraful, there is no seizure, my lord.
Acha.
My lord, meaning very clear, my lord, nothing has been recovered from me, my lord.
Yes, then.
And thereafter, my lord, I must be very honest that when I was at 26 days, that the bail was moved before the concerned authority. That, my lord, in page number 29.
29.
Yes.
Hmm. Yes.
And common order was passed and the bail was rejected. That the previous bail was rejected on the ground that the investigation was on the initial stage,
Same here.
my lord. Therefore, my lord, I am here in the SML subsequent bail application.
So only
And-
on the ground, nothing is seized.
My lord, nothing has ceased.
And what else?
My lord.
Any other ground for bail?
Yes, my lord, particularly in the, I have mentioned, since this is the subsequent bail, so a specific reason has been mentioned in para 9 of my
This
bail
is
application.
subsequent bail. This is before session judge. You have not moved before High Court.
This is press bail.
Well,
Huh?
Press bail before.
This is the first bail application, I think.
yes, this is part
Before
before
High
this
Court.
one.
Yes.
Yes. Now, my lord, my submission and the argument point of view, my lord, why I should be released on bail. My respectful submission before the lordship is that, my lord. The authority has got the ample opportunity. Till today, I am inside the jail for 49 days. Since my case is very clear that there was no recovery from me, my lord, my case should have been, investigation has already completed. And I hope that, my lord, that is in the CD, my lord, that I have stated, I have already, my statement has been recorded. Therefore, my lord, further detention is not necessary in my case. And my lord, it need not to explain, but my lord, so far the cardinal principles of the criminal law, my lord, until and unless, my lord, the competent court has not been convicted, my lord,
You are innocent.
Still I am innocent.
That is okay.
Therefore, my lord, in the name of investigation, further investigation or further detention against me is, my lord, against the, my lord, personal liberty, my lord. Therefore, I am praying before this honorable court that my personal liberty may be obtained by granting the, my lord, bail. And for that, my lord, I am ready to accept all the term and condition, whatever will be, my lord, imposed by this honorable court. And finally, my lord, I am to add that bail mean, my lord, to make sure that, my lord, all we appear before the honorable court as and
I
when
couldn't get
required.
what? Oh, acha, to appear before the honorable court.
My lord,
Now the charge sheet is not filed, you'll have to appear before, if I grant you bail,
my lord,
before the investigating officer. Acha.
before the investigating officer, before the charge sheet. And therefore, my lord, in total, my lord, all the, whatever the term and condition, then I am ready to abide by, my lord. And to bail mean, my lord, make ensure that I will be present and I will be cooperating all the conditions, my lord.
That I, okay,
My lord,
that is all.
my lord.
Okay.
So this,
Nothing is seized from him?
Your lordship, nothing is seized from it, but they both came together in the same motorcycle. Your lordship.
That is there.
And that submission I've made that he has a conscious possession, my lord. He, although not in person, it has not been recovered from him, but he has a knowledge that that person is possessing that contraband substance. And that conscious possession is there.
Just let me go through the FIR. The team apprehended. They have been identified so and so. They were served with remand. Upon searching, 2 plastic pouches containing 13.3 grams
And
marked as Exhibit E and 11.4 grams marked as so and so contained in 2 separate brown colored soap boxes were recovered from the possession of Sheikh Farid. Came from Lakhimpur to sell such contraband to Naharlagun. Total 73 grams. Acha, how it is 48.7 gram from Sariful,
yes, your lordship.
right?
Yes.
Okay.
And your lordship,
But whatever, he was together, but then
yes.
you can,
And he is the person who met with the customer, prospective customer, and then came along later on came along with this the first bail applicant, your
who
lordship.
said that?
Your
My lord.
lordship, in the your lordship, statement is in the status report itself, my lord.
my lord, I am answer for that, my lord. My lord,
And what did the witnesses say? What did the police say in his?
Your lordship,
so in fact, my lord, this is the mere allegation against me. So I'm not supposed to be disclosed this type of the facts. But what the fact is, my lord, that so my entangle is that only the person who carried this contraband item, my lord, that I am not aware of it. But by virtue of, my lord, recognize each other, I was asked to drop, and accordingly being,
Anything can be there.
my lord.
I will not.
my lord, the status from second para, my lord. From second para onward.
And one thing what I'm trying to display, my lord, is here in the IO of the case, my lord, I was asked, I was demanded, my lord, that I should pay something to him so that I should not entangle in this case. But since I am
These are-
innocent,
these
it was
are
not
to be-
denied, it
these-
was denied.
Not to be stated, these
My
are, I'll go through the
Yes, sir.
paragraph 2. One, sorry.
They both were together, my lord.
He was
And your
served
lordship,
with
although
so-and-so.
37 will not strictly follow, but so far as 37 of NDPS concerned,
Hmm.
negation of bail is a rule and is granting an exceptional in NDPS case, my lord.
Yes. Upon examination, disclose. These are the same statements.
On the later part, my lord, it will come here, lordship, on the next page. my lord.
Uh,
Next page, your lordship.
And my lord,
Wait. Sorry, full from the rented house. We recovered seats from now. Yes, I've gone through Mr. Ette, but then still nothing was recovered from him.
Yes, your lordship.
And you never know who is arrested with whom anything can be written. So in his case, I think I'll make an exception and grant him bail.
Yes, my lord, but so far as your lordship is, recovery of possession is concerned, your lordship, I will give an authority where it says by the Honorable Supreme Court that even if the contraband is not recovered from the possession of the person, that alone cannot be a ground of granting bail to that person. Only because he has not been found to be in possession of contraband substance. Because,
Let me
be-
see the judgment.
yes, your lordship, because your lordship, the aspect of constructive custody is also there, your lordship.
Mm.
So, your lordship, I will come in, your lordship. There, your lordship. 2021, my lord.
Yeah,
Both,
I'll take out.
yes, your lordship.
Do you have copy?
Yes, my lord. And they've, I have
Acha,
the
I'll
soft
take
copy.
it out from here then. What? 2000?
2021, volume 10.
Wait. SSC?
Yes, my lord. Page 100.
Year 2000?
2021, 10,
10.
page 100, my lord. In para,
Union of India versus Nawaz Khan.
yes, my lord. Para 28 and 29, my lord.
The paragraphs might not tell you.
Okay.
28, mine is Manupatra. What is yours?
Okay, mine is SCC, my lord.
Acha,
Is
how
the-
does it start?
My lord, as regard the finding of the High Court
Okay,
regarding
okay.
absence of recovery.
Hmm.
May I read, my lord?
Yes.
As regard the finding of the High Court regarding absence of recovery of the contraband from the possession of the respondent, we note that in Union of India versus Ratan Malik, a two-bench judge of this court cancelled the bail of the accused and reversed the finding of the High Court, which held that a contraband heroin was recovered from a specifically made cavity above the cabin of a truck. No contraband was found in the possession of the accused. The court observed that merely making a finding on the possession of the contraband did not fulfill the parameter of 37(1)(b), and there was no application of mine by the High Court, your lordship.
No, no, there is a difference. Like if you get a contraband in a vehicle, in the dicky and all, and the two persons are sitting, then constructive possession and all will come. Conscious
Yes,
constructive.
here also, your lordship, they both were intercepted while coming in the Dominor, Bajaj Dominor together, madam.
Not together.
Yes, your lordship.
Contrabands were found in the pocket of the other
Other,
accused.
yes, my lord.
In the person.
Yes, your
not
lordship.
the vehicle or something.
Yes, my lord. Now, the question here is, your lordship, since they both were together in the motorcycle, and there was, your lordship, although the statement is not there today, but I have gone through the record, your lordship, where it has.
Shuffle statement will be here with you. Case diary is here now.
Yeah, that is what your lordship said. No statement has been the
That's
part of the. Otherwise, your lordship, it's quite easy for me to make submission.
Hmm.
So, your lordship, they both were come together from the bike Dominor, and there is a your lordship statement that he first went to the customer, the Ashraf, and then he came back and he came along with the co-accused, this person, in the motorcycle, and the one of the co-accused, which were.
But that story is not there in the FIR, only that they tried to apprehend and they
No, your lordship, that part is there, your lordship. I have gone through the. Since they have not given the particular statement also, your lordship, it will quite difficult for me because it is not what I on itself constructed the story. It's there in the record, madam.
Do one thing,
Yes,
get the record on Monday,
Yes, your lordship.
then we will here dispose
Yeah,
about the
that will be
petition.
better, my lord, because the story has to be clear, fact has to be clear because of the.
Because now it is bail. I'll
Yes.
have to consider the case
Yes,
diary.
your lordship. Because possession, my lord, the possession cannot be the sole ground because the material, if suppose prosecution able to connect this both the accused, that if they were together, then your lordship, the conscious possession come. And if other materials are there, suppose there is a material to show that yes, he went to somewhere, the other customer, prospective customer, and then he came along with this person, then it's culpable mental element clearly established, your lordship.
Then your constructive.
Yes, your
will
lordship,
come.
possession will be there. So On that I am submitting, my
Okay,
lord.
then let.
Yes,
bring-
everything come, my lord.
Because the case diary is not complete, it seems.
Yes, your lordship.
So let the complete case diary come Monday.
Monday.
The other case I fixed on Monday.
Yes, yes, my lord.
So Monday we will take it up.
No,
Yes,
no
ma'am.
issue, ma'am.
Right, Mr. Swans and Mr. T. Ete. Mr. T. Ete submits before this court that the case diary is although available, but the same is not complete. And as such, he prays for some time to bring the complete case diary. Prayer is allowed. List the matter on Monday, 30th.
Oblige, my lord.
Take this. From this, the grounds of arrest. These are, I think, sealed with the name. Huh?
My lord, that will be the part of the record, my lord, the ground of arrest.
Ah.
Okay.
No, take it back.
Yeah, yeah.
So that the
On
case
Monday-
diary becomes complete.
Yes, wait.
And what is this? Oh, this is in respect of the other case. This constable or those captains. I think there was a prayer for adjournment.
No.
Oh, yes, they wanted to call the affidavit. That's it.
May it please your
This
lord.
is AV.
BC, your conducting counsel, he will appear through BC. He's there now.
I couldn't get it. What conducting?
May I please, Lordship? Lordship, Mr. PD Nair, Learned Counsel, he will be appearing through BC.
PC. Oh,
Yes, yes, sir.
May it
But
please
then
your.
I cannot hear you. Your voice is, you're not audible.
Am I audible now, ladyship? Am I audible now?
No.
Your lordship, if I may pray, your lordship, in that case, I've got the CD, your lordship, but then CD does not consist of the medical report, your lordship. In this matter, the ear of the victim was bitten off or cut off.
Oh,
That has to be
chopped off.
Yes, chopped off.
Oh, that is different case and this is different.
Yes, your lord.
Huh? There's a chopped off something, right?
Yes, your lord.
Lordship, yes. The one interim was granted in that matter.
But that is a different matter.
No, same matter, Lordship.
Same matter.
Co-accused. Co-accused by order dated 23rd, 6, 2025.
Yeah.
Because
Chachi Nabam.
Yes, yes.
Yes.
That was in respect of co-accused.
Co-accused, yes. Yani Nablam Dada. Same, arising out of same FIR.
Ah.
And it was alleged that they were together on that day.
Yes. And
It's an
I
FIR.
may be.
Yes.
But
Interim.
this is saying that the medical report is not there.
Yes, because 118, section 118 is there, your lordship, which is voluntarily causing hurt or grievous hurt by dangerous weapon. If
Mm.
it's not a dangerous weapon and it was bit off by biting it, or that has to be a certain, if that is so.
Okay. So, Mr. Nair,
My lord.
I still cannot hear you. There's some problem with the
Oh.
network.
I'm so sorry, my lord. I'm so sorry.
Acha, you have some representative here.
Yes, my lord.
Lordship,
You are here.
yeah,
na?
I
So-
was supposed to assist him.
There's something wrong. Or there's something wrong in our code. No, na? Okay. Acha. So,
Day after
I
tomorrow.
think you can hear Miss Jeannie has prayed that her case diary does not contain the medical report. So, because the ear and all are chopped off, so we need the
My-
medical report. So we will take it up next week.
My lord, on the
Lordship,
second,
This is,
Ah.
since this instant applicant, Lordship, she is a government servant, Lordship. So, in fact, Lordship, in that case, till this matter is taken up, interim may be granted, Lordship.
Interim again, I have to see, right?
Lordship,
We cannot just-
basically, this case, Lordship, I'll just make it short, Lordship.
Facts, but then,
Lordship, this, there was a, Lordship, in fact, I have filed additional affidavit also, which will show that this, there was a extramarital affairs
huh,
between
that is
the,
deeper.
yes, between the husband of this present applicant and the victim.
Hmm.
And husband and victims, this present applicant and alleged victim, they are cousins actually, Lordship. So taking advantage, of those closeness, they started, this husband of the alleged accused and the victim, alleged victim, they started having extramarital affairs, and it has been going on for the past 15 months. So considering that, after that there was an issue in the family, so at SEPA is, which is the different district, is coming district. They belongs to from it is coming district lordship. Now they enter into an agreement there. Agreement dated 15/1/2025 lordship. And there, if your lordship will see, there in that agreement lordship, it has clearly written that in fact this both the parties, alleged victim as well as the husband. And in fact, it is a three-party agreement, lordship. Now, in that agreement, lordship, both the parties said that they will not continue with the extramarital affairs. So that was their sworn.
That also agreement, they will not continue.
Lordship, and it was also notarized, lordship. In fact, it was notarized before notary public, lordship. Now, thereafter, what did happen, lordship? On this fateful day, lordship, since this alleged accused person was alleged accused person along with some other co-accused person, they were
I
actually,
remember.
yes,
To
they
see some land and.
land at Poma, lordship. So that was the issue, and all of a sudden, the present accused person saw her husband and the alleged victim meeting at the place of occurrence. So, out of in the fit of rage, she confronted the accused, and then there was a scuffle, lordship. I'm not denying that there is no scuffle. There was in fact scuffle, and then all those others. It was in the fit of rage, lordship. There was no knife or sharp weapon was used as alleged in the FIR, and it was not in fact premeditated, lordship. Offense, lordship. It was in the spur of moment, lordship. In the heat of moment, lordship. These things happened because there was a violation of agreement, and in fact, lordship. The interesting thing is they have, in fact, in the deed of agreement, lordship, they have said that to do whatsoever. I mean, if that they are found to be indulged in extramarital affairs. So, therefore, lordship, since this lordship, although this appears to be, I mean, if we go by the FIR, it appears to be very serious, lordship. However, the fact of the matter remains that the present victim indulged in extramarital affairs with the husband of the present accused, and all those persons, those who were in the car and those who were trying to stop this couple, all of them had been met as an accused in the present case.
Yes, I have seen.
So that,
but nothing specific against any one accused.
lordship, in fact, one AB was also filed by the co-accused, and that was subsequently withdrawn because CF recorded. Police came to her place, and then from there she went to the police station, and then in those even that accused was police was of the view that her custodial interrogation is not required.
No
So-
specific act against any of the ladies.
Lordship.
There were 4 ladies together.
The
Lordship.
statement given by them, the co-accused are there, your lordship. They admit to the fact that they have
The-
beaten up the. But my only prayer is that, your lordship, if your lordship fix this matter on day after tomorrow. Why? Because only 108(2) is non-bailable, your lordship. If there was no weapon use, I don't have any ground for objection, your lordship. Only to ascertain that I need the medical certificate, your lordship.
Lordship,
Only day
I-
after tomorrow.
But again, even if some weapon is used,
Yes.
but who had used? That will be.
That
again
has been,
required.
that will be substantiated by the statement of the co-accused, your lordship.
Lordship, all the
Because-
co-accused has already recorded their statement, lordship, in this case. And in fact, the co-accused person, one has initially filed anticipatory bail before the learned sessions court.
That is a minor.
Yes, no, that was not a minor. She is one of the co-accused. If I may take your lordship to the FIR, lordship, here, Mebing Lamgu
Seen,
Kipa.
I have seen.
Mebing Lamgu Kipa, initially she filed the anticipatory bail, and later on she was not granted interim protection. Police came to her place, and then from there she went to police station, and thereafter she recorded her statement, everything, she has divulged everything, and even in her statement, she has not mentioned that this particular person has done the alleged offense, and there is no question of lordship. using sharp weapon, because everything, whatever is there, everything is recorded in the CCTV footage installed at the
But
place of
chopping
occurrence.
the ear, it will not be possible by anything else. There has to be something
No.
sharp.
Lordship,
But who had used this? That is again, if it is reflected in the case diary, but the statement of some co-accused, then it's okay.
co-accused, Lordship, co-accused,
Co-accused statement is again a weak piece that will again come.
Lordship.
But
Now, Lordship, if everything, if we go by the, I mean, allegations also, Lordship, there is a CCTV footage installed in the area. So if
these are subject matter of the trial.
Yes, Lordship.
These are-
But even there, if the allegation is sharp weapon were used, but as per the CCTV footage, it is very clear, Lordship. Nothing was used. It was a sudden, Lordship, as I have submitted earlier. It was a scuffle.
2 days.
Lordship, in the meantime,
2 days, nothing will happen. Why interim
Lordship,
now?
Lordship, interim may be granted so that she can record her statement, Lordship, till 2 days, Lordship. If anything adverse come, Lordship, it's up to Lordship to either vacate it, Lordship.
But one thing, Ms. Ginny, since even if you find that it had some sharp weapon, as I said, who had done it, who had given the blow will not be clear. And even co-accused statement is a weak piece.
Yes, yes.
Lordship.
So there has to be proper evidence.
So my only concern is that was it just bitten by the teeth? Because FIR said chopped. Because I'm not into.
But teeth, it will not be possible.
That's what I just want. Therefore, the MLC even by teeth, if it was chopped off also, with that 118 will come, because 118 is more particular with grievous hurt by weapon. The teeth is not, since it does not come under the definition of weapon, it would not lie. So only to ascertain that, because then I won't have any objection to granting of bail in terms of 118, Your Lordship. Only to ascertain that, Your Lordship. Was it chopped off or was it just bitten?
Lordship,
So be ascertained.
that can be ascertained, Lordship, if at all, as I prayed, Lordship, if anything adverse come, it's up to your Lordship whether to vacate the interim or, I mean,
He's a
Lordship, make
government
it
servant.
absent. She is a government servant, mother of 5, Lordship, and then she has been working as lower division clerk. So in the event of arrest, she will be suspended, Lordship. So if just for these 2 days, let the accused person record her statement. If anything adverse is found by the investigating officer, it's up to your Lordship to either vacate it, Lordship, on the next day. So just for
story, there is nothing to disbelieve, right? The story.
Yes, even
So in the said story, and then the ladies had gone and had come back and had seen that part, and they got enraged, and then something happened. How her ear is chopped, we are not very clear.
Yes. Because only
So-
118 is, even the punishment is a bit serious.
So let me give the interim and you bring the
I don't have
statement
issue on that.
on that particular. So heard, Mr. PD Nair, you write PD Nair, assisted by so-and-so. For the petitioners, and Ms. Jeannie for the learned public prosecutor, additional. What is this? Additional affidavit by Chachi? The same thing, right?
yes.
Oh, that is what you brought.
Yeah.
Why did you bring this? Why have you filed this?
Lordship, that is to bring that deed of agreement in record, Lordship.
Oh, achha, okay. This is an application filed under section 482 of the BNSS 2023. Praying for, you can say, praying for grant of pre-arrest bail to the accused person, namely Srimati Chachi Lamgu, alias Nablam, in connection with Itanagar Police Station case number 88 of 2025, registered under section 126(2) 126 within bracket 2 / 118 within bracket 2 of BNS 2023. The allegation against the petitioner, namely Chachi Lambam Langu, Chachi Nablam Lamgu, as is revealed from the first information report dated 29th of May 2025, is that the petitioner, along with three other ladies, right? Along with three identified persons. Acha. Chachi Lambam, Yani 2, 3, 4. Along with 4 other accused persons and 3 unidentified accused persons. In a premeditated and coordinated manner, physically assaulted the informant using deadly weapons such as local made knife and machete, M-A-C-H-E-T-E, chopped off the right ear of the informant. It was also stated in the FIR that after beating her mercilessly, the accused persons, including the petitioner, took her bag and mobile phone. And that, seeing the nature of the act, it could be safely deduced that the same was a premeditated criminal act punishable under the law. The police, on receipt of the FIR, registered the case as Itanagar Police Station case number 88 of 25 under section 61 within bracket 2 / 126 within bracket 2 / 118 within bracket 2 of BNS 2023. The Mr. Nair, appearing for the petitioners, submits before this honorable court, that the real facts culminating in the FIR is that the informant and the husband of the petitioner were having an illicit relationship since many months. The petitioner, for many months, for which the petitioner was infuriated as the same is normal in the said facts. The learned counsel for the petitioner, by filing an additional affidavit, had brought on record the deed of agreement between the informant and the husband of the petitioner, right? Informant and husband of petitioner.
Yes, Lordship.
Husband of petitioner is Denny Lamgu
Yes, Lordship.
and informant is Baby Lambam.
Yes, baby Navlam, Lordship.
And a deed of agreement between the husband of the petitioner and the informant, wherein it was agreed that both of them would refrain from any illicit relationship and that they will not further contact each other. It was further agreed upon that if the informant contacts and communicates the husband of the petitioner, then her family members would take legal action against the informant as per law. It was also agreed upon that both the husband of the petitioner and the petitioner will not recall the present issue, will not recall the issue of the illicit relationship in the future, and further promise that they as well as their relatives will never defame the reputation of the informant ever after. The counsel for the petitioner states that on the day when the Ejahar was lodged, the petitioner, along with the 3 other accused persons, along with as well as with 3 other unidentified persons, went for some business purpose, and while they were coming back, they saw the petitioner along with the husband. They saw the informant along with the husband of the petitioner. And as such, the petitioner got infuriated and there was a quarrel between her and the informant, and all others got involved in the same. And as such, he prays, and as such, he submits that there was no premeditation on the part of the petitioner, and there was no intention on the part of the petitioner to do any unpleasant act, or much less do any unpleasant act, much less assaulting the informant. On the other hand, Miss Ginny submits before this court that although she has the case diary with her, but she does not have, as it was not provided to her, the medical report of the victim. Full stop. She submits that had the medical report been there, she would have been clear as to whether any weapon was used in the incident, since there is allegation that the ear of the informant was chopped off. She as such prays for some time to get the medical report, and then the matter to be taken up. That is all right.
Yes,
And
Your Lordship.
something else? No.
No, Your Lordship.
I've heard the parties and have perused the records. It is seen that there was an agreement between the petitioner, between the informant and the husband of the petitioner, which is brought on record, by way of an additional affidavit, whereby
It's going to take an, will do take a money now.
the illicit relationship between the husband of the husband of the petitioner and the informant is writ large. And in the said agreement, it was also stated that they will not continue with the relationship any further. The agreement was entered into on 15th of January 2025. Where is the pleading about the relationship?
Relationship, lordship,
Yes, 4.
yes, 4, 5, 6, 7 here.
It is a pleaded case of the petitioner that the extramarital affair has been going on between the petitioner, between the informant and the husband of the petitioner for the past 15 months, and despite request and prayer from the applicant, the relationship was continuing. And on 24th of May 2025, that is after almost 4 months of the agreement, when the petitioner was coming with other ladies, other
Relatives,
friends, huh?
relatives.
Relatives.
Yes, all.
We're coming with other relatives and relatives from a business purpose after finishing some business transactions. She saw the informant and the husband and her husband together. Where have you written this? That why
5.
they, huh?
Para 5, lordship.
Para 5.
Yes, 1, 2, 3, 4, 5,
Mhm.
6, 7, 8, 9. Ninth line.
Upon seeing the same, the applicant got infuriated and confronted the informant, and it resulted in a scuffle between them. It is a further pleaded case of the petitioners that the applicant had not inflicted any injuries upon the informant as alleged in the FIR. The argument raised by Ms. T. Ginny, the learned additional public prosecutor, that the medical report would substantiate as to whether any weapon was used in assaulting the informant, the same would not be sufficient to reach a finding as to who exactly had assaulted the informant. Since there were other accused persons as well as some unidentified persons in the said place of occurrence. And there can be some public people also, because they stop,
Lordship,
right?
yes, yes.
Further, there can be more persons because the incident took place in a occurred in a public place. In the FIR, no specific act is attributed to any of the accused person as to who did what activity, much less who had assaulted the informant. Well, in the facts mentioned above, this court therefore enlarges the petitioner on a pre-arrest bail upon furnishing a bail bond of rupees 30,000. Okay? Yes?
Lordship, in other case, it was 20,000, Lordship.
Acha. Okay. By furnishing of bail bond of rupees 20,000. Okay, Ginny?
Yes, Your Lordship.
20,000 with two sureties, one being local inhabitant of the state of Arunachal Pradesh, to the satisfaction of the CJM.
No, this investigation is still.
Yeah.
Oh, yes, to the satisfaction of the investigating officer of the instant case. The pre-arrest bail is, however, subject to the following conditions. 1, 2, 3, 4, I'll give those
Lordship.
the condition. She will appear before the investigating officer as and when she is called for.
No, Your Lordship, since she is absconding, Your Lordship, if Your Lordship gives a particular date
Of appearance.
of appearance, Your Lordship, within 2 days or certain some.
Lordship, the difficulty, Lordship, with giving a particular date is that we have to, even after the completion of the investigation, unless that particular order is modified, the accused person has to keep on going, Lordship. In one instances, bail was granted by Supreme Court in this APCS case. So they have
No,
to.
she will go and give her statement before the investigating officer within 10 days
Yes.
from today.
Yes, Lord.
And then she is working in Arunachal Pradesh.
Lordship, yes, SEPA is coming this week.
Okay. And then she will go and cooperate with the investigation.
Yes,
That is
as and
what
when
I'm saying.
required, Lordship.
Okay.
Your Lordship, I'll just pray, Your Lordship. A short date may be given because, as I have already prayed, Your Lordship, my objection would only depend upon the MLC. I have got the CD, Your Lordship. This is of Papumpare district, Your Lordship. MLC, since Your Lordship can also call for scan copy of the MLC, Your Lordship. Only that is needed, Your Lordship. Now, after 10 days, there is a summer vacation, Your Lordship. It's better if the case
Okay,
is
within
disposed of
5
by
days. Within 5 days.
Lordship.
She will go and give her statement within 5 days.
Lordship, in one case, this matter is fixed on 22nd of 22nd July.
So
Similar matter.
it's on 22nd July only.
Yes, yes.
By the time she'll get the medical report. Okay. So these conditions. Then after that, you write to call for the CD. Oh, CD. Missed.
return the CD and updated CD, Your Lordship, in that
Okay.
case.
The learned government advocate is allowed to return the CD and to get an up-to-date case diary along with the medical report. And
And the statement of all the
and along with the statements
statements, Your Lordship,
of the accused persons
and witnesses, Your Lordship.
as well as witness. Those will be there.
Yes,
And fix the matter on
22nd.
22nd
release the matter on 22nd of July.
July.
So July 2025.
Deeply,
Those simple conditions, 5 days, and then he will cooperate.
Lordship.
If you-
Deeply obliged.
Yes, Mr. Nair.
Deeply obliged.
For orders, why has it come? Steps for service upon is not taken. You have not taken steps,
We have taken the step, ma'am.
but then the office note shows that you have not.
Ma'am, that the service report is not yet received.
Steps for service not yet taken. Take it.
You have taken, sir, ma'am.
Where is that acknowledgement? You have that.
No, ma'am, I don't have that.
If you can place it, then I could have told the registry to do the needful.
Yes, ma'am, actually I was directed to.
Okay, I heard Mr. So-and-so. You are Pada.
Yes, no, no, I'm reading.
You are appearing. Heard so-and-so. Appearing for Mr. O Pada for the appellant. This is criminal appeal.
Yes.
This is POCSO.
No, no.
Wait. This is criminal appeal.
NIA.
NBW.
No, no, NIA.
Huh?
NIA.
NI. Oh, NI. Then to require. Okay. Mr. So-and-so appearing for so-and-so. Okay. It is reflected in the office note dated 24/6/25 that the petitioner had not taken steps for service of notice upon the sole respondent, right? Sole respondent.
Yes.
Full stop. However, the counsel appearing for the petitioner states that he had taken steps. It is as such directed that the registry would inquire and do the needful.
Ma'am, actually I was directed to ask to take a fresh step.
That you have not taken.
No, actually we've taken, but I don't have that.
No, that is what you should have. You should have that acknowledgement. Otherwise, fresh steps were directed to be taken on 10/4
Yes.
and 24/6. You have not taken. Are you sure you have taken?
Yes.
Maybe you have taken earlier, not the fresh steps.
No, ma'am, we have taken the fresh step.
Okay. Then registry, let me inquire about the same. Inquire about the same full stop. The counsel may also assist the registry in the said inquiry, the matter to be listed after 2 weeks. And if it is found, you write, if it is found, the petitioner has not taken steps, the petitioner is directed to take steps within a period of 3 days from today. Okay? First you go with the registry, talk with the registry, then take first steps.
Yes, my lord, I am for the private respondent number 2.
You have filed your wakalatnama.
Yes, I filed Vakalatnama.
Hmm.
And lordship, I didn't receive the petition copy. I've obtained through the CTC only. So
Give him, what, you are for respondent number 2?
yes,
You are for?
I'm for state lordship.
Oh, you are the state, yes.
yes.
So where is the petitioners? The petitioners are not present. You are there in item number 15?
No.
Oh, you are not there. Okay,
Okay.
right. None appears for the petitioners on call.
Lordship, next time we picks after the summer vacation, lordship.
None appears on call. Mr. So-and-so appears for respondent number 2. And Lakshmi Hage,
Yes, I'm
Yeah.
for state lordship.
the learned additional public prosecutor appears for the state. But Mr. So-and-so appearing for respondent number
And
2
Kumar.
submits that
Yes.
he has not got the papers. But the petitioner is not there. Who is there to serve you the copy?
Lordship, I have only received the dishonorable court order copy only. It was the WhatsApp. The petitioner has sent me only to the WhatsApp only.
Let the matter come up after a week. When the person comes, then I can tell him to give you a copy.
Lordship, I have obtained through the CTC only from dishonorable court.
They've already obtained through CTC lordship.
Or you have the
Yes,
petition
yes,
copy.
yes. Just a few days ago, I obtained.
Then it's okay. You
Yes.
can so cut it that he has not received. So and so none appears and they are there. List after 2 weeks
Lordship,
on a
here-
date to be fixed by the
One
registry.
interim is there lordship.
Interim, interim passed earlier shall continue till the next date.
Obliged lordship.
Obliged, lordship.
You sure interim is there?
Yes, interim is there.
Okay.
Obliged lordship.
So why has it come for orders? Scan copy has been received and the same is placed with record. There was some paucity of time. When was it? 23/6. So you want to do it today?
Lordship, actually this happened, Lordship. My senior counsel is just for emergency, not here, Lordship. So this matter may be fixed, Lordship, 1st of July, Lordship.
Okay. As prayed for by so and so appearing on behalf of Mr.
And again, I'm Mr. Honi Tanatara, Lordship.
Yes. Matter to be listed
1st July, Lordship.
after 2 weeks.
1st July, Lordship.
Huh?
1st July.
1st July.
Yes, Lordship.
July is
Monday,
Tuesday.
Lordship. Tuesday, yes, Lordship, Tuesday.
You want to do it?
Yes, Lordship.
Okay. Matter, list the matter on 1st of July 2025.
Yes, dear faith, Lordship.
But it was for orders, right? Otherwise, everything is served and all.
Yes, Lord.
Achha. No one. Oh, Mr.
My lord, in this matter, in the record, it shows that the service notice upon respondents were returned unserved on the address given. So, my lord, I may be allowed to search for new address.
Where will you get the new address? In the records?
Within some specific,
TCR is here. Item 17, right?
no, 1818.
18. Okay, you try to get the proper address.
Yes.
Heard so and so.
In the meantime, my lord, the unserved copy of the petition may be returned back to the petitioner.
But that I don't know whether it is returned.
Yes, it is written. I've checked.
It is returned back to the registry in respect of respond number so and so. After issue of notice, I either through the essay and report mentioned are not found in the hence return.
So that I can take again fresh.
FPG record.
It is already there.
But that I'm not aware of whether it is given back.
It is
to
already
the-
there in the court.
Okay.
Yes.
Oh, these are.
Yes.
This can be returned, I think, right?
Yes.
What will they do otherwise?
Yes,
Okay. Heard so and so for the petitioner. It is noticed from the office note that the service of notice upon respondent number 1 to 5 could not be effected due to what? Wrong address.
Actually, not wrong address. It is record shows that
They are not found.
yes, sir, in
Okay.
that address.
What did I say? Affected, and the same was returned
I'm sorry.
as the respondents, as the said respondents could not be found in the given address. Mr. So-and-so prays that the copy of the petition may be returned to him and that he would make endeavor to get the correct address of the respondents and take fresh steps for service of notice upon them. Prayer is allowed.
My lord, trustee service may be allowed.
Okay. The petitioner is allowed to take fresh steps. Only Dusty or
No, no.
registered post also?
Yes, as well as.
With registered, by registered post with AD,
As well as usual.
as well as usual course, as well as Dusty. They know how to write, I think, Dusty. And after service of the notice, as well as Dusty, full stop. Listed after 2 weeks.
3 weeks.
3 weeks, okay. In between, how
Okay.
days are there?
Yes. My lord, apologize. There is interim.
Oh, interim order passed earlier should continue till the next date.
Apologize.
This is BA.
Yes, Lordship, bail application. Regular bail.
Respondent number 2 is not served.
Yes, Lordship.
Acha, this is a POCSO or what?
Yes, Lordship.
Oh, then they'll have to be heard.
Yes, Lordship.
Why has it been listed for orders today?
Lordship, last occasion, Lordship, this scan copy of the TCR was called for.
It is here.
Yes, Lordship.
Scan copy is received
Yes, Lordship.
and the same is placed on record. So today you'll move it or some other day?
Yeah, yes, Your Honor, the item may be listed after 3 weeks, yeah.
Okay. On the prayer made by Mr. So-and-so, appearing for the petitioner, list the case after 3 weeks.
Obliged, Lordship.
In respect of which matter I forgot. No, Ashraful, not required.